Good morning, good morning, good morning. It's Thursday, it's July 11th. Today we are traveling to Idaho. Replay crew, love you as always. Everything is timestamped below if you want to get to the parts of cases you want to see or the parts of cases you don't want to see. The timestamps will help you zoom around the stream. Then again, who knows how long the stream will be, because at the beginning of stream, it's like the world is our oyster. Anything is possible. Sometimes we end up with today we don't have too much to talk about. And 5 hours later, I'm like, oh wow, we're just chatting. But today we're going to be chatting in Idaho about Bryan Kohberger and about the TikTok psychic. If some of you are like, what is the TikTok psychic case? I hate to even call it that. I tend to call it the TikTok defamation case because let's call it what it is. But it is a defamation case that stemmed from the Kohberger case, from someone slandering one of the university professors, defaming them on TikTok. And yes, slander and libel are different parts of defamation. And this is technically probably libel because most of it was spoken, no slander, and not written libel, but you know what I mean. So that defamation case is still going. If you are new to that case, you are going to ask me one question first. How is this still in court? And what I am going to say to you, to a very unsatisfactory answer, is that the professor had to bring the case as the plaintiff, and they can't just dismiss it until the other party stops it. And that is incredibly frustrating. But it's not the person that is doing the defaming that brought the suit. So there's really no good recourse other than going through the legal process, which has been going on for years now. We'll talk about that and how frustrating that can be, because it is a very frustrating thing. Because how do you protect your name and reputation? And really, let's be completely honest. For a professor that might want to change jobs at some point, academia can be pretty rough. And if you want to change jobs at some point, the reality from just how I see it as someone who has worked adjacent to that field is, how do you find new work if this noodly Googling is going to come up? I would hope to think that the university overlords that be would have everyone's best interest in mind, but I've become a bit more cynical than that, unfortunately. And I worry that for this professor, these Google searches will come up, and even though intellectuals should be able to say, we know this is all BS, they also might see it as, but we don't want to touch that. Like, that looks like a big old mess. That could be a big old mess. And how do you protect yourself against that? Even if somebody's like, well, no, I know it's not true, but it's like, it's a lot. So what do you do? What do you do? Goldilocks, no, I just have a hat on and my hair's up in like a bun in the back. No haircut. Just, I love my fax hat, and it's been a long couple of days. So reducing some of the overhead light helps me stay focused, and that is hugely needed. So it's a frustrating case, because it's like, even if everybody looks at this and goes, I objectively know it's not true, it still becomes one of those things where I'm like, I know it's not true, but other universities might not want to touch it. I think it's cowardly, but also I can understand where university overlords and corporations are just like, we don't need the mob of angry comments to turn on us, and we're going to try to limit those possibilities, because online mobs can get very, very loud. And it's something I think people try to like duck and cover from because they don't really know how to well deal with it. I think in a situation like this, a university should say, that's all defamation, none of it's true. So be mad, stay mad, I guess. This is a great professor, and I don't know much beyond that, but these are the reasons that these cases are so frustrating. And it's the reason that I keep covering them long after the headlines are gone, because you saw all the headlines at the beginning about her being accused, and you don't see any of the positive outcome because it takes so long. If there's a positive outcome or negative outcome. Lona asked, isn't that discrimination though? Bad PR is not a protected class. So no. And I'm sure they would never say it out loud that like, we're not hiring you because of this. But I can imagine that this is something the professor would always wonder, or the professor's been supported by the University of Idaho. Maybe it's like, this is where I'm at and this is where I'm staying. And this is where I'm building my career. Maybe, but it points out why it's so hard for these cases. Okay, let's grab your favorite beverage. I got a coffee, and let me know where you are coming in from, what you're drinking. We're gonna roll the intro. We're gonna fly to Idaho. We're gonna talk about Kohberger first. We're gonna talk about defamation second. So if you're like, ooh, I know, and everything will be timestamped down below when you come back on the replay to watch it. So it'll be great. Let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, so we're going to talk all things Kohberger first, and you saw the title for the show today, which is Signed Confession. I started seeing these headlines and questions in the chat a few days ago, and I was like, what is everybody talking about? And then I went back through the docket, and all of the written things that happened in court are on the docket now. So if you watch that day in court with us on the Kohberger case, you have seen these things, even if you have not seen them yet in writing. So we are going to go through what has been written out, which is going to include the factual basis that the prosecution read. It's going to include what Bryan Kohberger signed and the plea agreement that he signed. We're going to go through those. Then we're going to get to the fight over the non-dissemination order. Remember in court, the judge said, well, the plea's been entered. I think we can lift the non-dissemination order. And the prosecutor was like, no, please don't do that. And I'm like, really? That's weird. It should be lifted next Wednesday when this comes to a full day, maybe a day and a half, I suspect, for the sentencing hearing with impact statements and what have you. But it seems that waiting is not going to be sufficient. So I feel like what we should do is just fly to Idaho and get this party started. I don't, in the colloquial sense, because all of this is horribly sad, and we're going to go through again what is signed, different than what we heard in court, but some of it will be, I think, duplicative of what we heard in court. But also I've seen tons of these headlines about signed confession, and then some people saying Bryan Kohberger did not confess. And so I think we need to have a conversation about how we maybe use that word, because this saying, yes, I did the thing, I really categorize under that line of confession, though it seems that there are some that use that for, well, this is in the context of a plea deal, and so he's taking a plea deal. That's not a confession. Now, on the other side of that, I'm like, well, if you don't want to confess to a thing and you're taking a plea deal, then there's other types of pleas for that. Those wouldn't have been available here. But there's other types of pleas for that, saying I'm taking a plea deal, but I'm not admitting to responsibility. That's not going to work in this case. This is much discussion. Welcome to how my brain processes information. It's like, well, this. All right. I see Trish Nichols coming in from my old hometown. Good to see you. I, this morning, had a chocolate croissant from Wild Grain, which I adore, and my cappuccino. So we're just twinning this morning, though it's way earlier in California. Let's go to Idaho. So, are we ready? I was checking in with the team about the Fax Hat. We are getting low on stock of the Fax Hat, but they are still in stock. So I know a number of you have asked about the Fax Hat. So there we are. We're going to go through the things that were on the docket from the plea first, and then we will go through the new arguments about the gag order. Hopefully that makes sense for everyone. So let's take a look first at the redacted memorandum. Nope, that's the wrong one. That is the wrong, Emily, that's the old one. The plea agreement's the first thing we're going to take a look at. Once the dockets get into the hundreds of documents, it gets to be a little bit full. It gets to be a little bit full. Brittany Phillips in the chat said, does anyone know how the purple hoodie I have questions fits? It's oversized. So it's a drop shoulder and it is an oversized hoodie. So it is a oversized hoodie. If you get it in the size you would normally order, it will be oversized. If you want it to be not quite as oversized, I would size down a size. If you want to walk around in it like Ariana Grande with just like your head and your leggies pointing out, I would go up sizes, but it is oversized. And I love that about it. Okay. Let us continue with the written plea agreement. The court read this into the record. Sometimes it helps to see it in writing. I know for me, getting to take a look at things both in writing and hearing them really helps. And I know there was quite a lot of interest in what this plea agreement looked like. So we're going to go through what it looks like because, well, we're going to go through what it looks like. This is the signed plea agreement. You'll notice, I'm going to zoom to the bottom. You'll notice it is signed by Bryan Kohberger. It is signed by the attorneys, and it was stipulated on the 30th day of June. So right as we started hearing the rumblings about this is the day they signed it. So one of the big questions I had about this is I have to put hand lotion on because all of a sudden now my hands are too dry and it's making me mad. So that's what we're doing. Anyone else? I know. It's like, Emily, tell me how neurospicy you are. My hands are making me mad because they need hand lotion, right? Sometimes they're too lotiony and then they make me mad. I get it. We had wondered if this was signed, sealed, and done on that day. I said, yes, there is room for him to perhaps get to court and be like, no, I don't think so. Sometimes these agreements are done verbally. They did this in writing, which means Ann Taylor and the other defense attorneys would have gone to the jail, or someone from the defense team would have, gone to the jail and gotten Bryan Kohberger's signature and made sure that this was locked, and then told the victim's family. So that's why we saw all of this coming out on the 30th. So Ann Taylor's signature, Bryan Kohberger's signature, attorney Bill Thompson and attorney Ashley Jennings, they indicate that they signed afterwards. So the defense signed this first, and then it went to the prosecutors. So also, I'm sure lots of people have comments, questions, thoughts on Bryan Kohberger's signature. Again, there's so little we know about this case. Everything is going to get looked at. I don't know if he signed this while cuffed or not cuffed. So I don't have many thoughts about it because I don't know if he signed that cuffed or not cuffed. It's possible that he was cuffed to sign that. So we just don't know. All right. This is the plea. As it reads, Defendant Bryan Kohberger, the defendant's attorney Ann Taylor stipulate to the following plea. Defendant will enter guilty pleas to the following counts: burglary and then the murder counts, as stated in the indictment. So the full murder count. Defendant will be sentenced to 10 years fixed, count one, period. Fixed is done. The defendant will receive fixed consecutive life sentences after the other. And I know there's, once you serve a life sentence and you pass away, it's done. They're not going to go sentence you into like next lives. It's not a practical measure. A lot of times we will see this in cases that are going up on appeal in case there is an issue with one part of a case, or when you have multiple victims, if there's something overturned as to one victim but not another, you have backup sentences. I also think yesterday when we were talking about the Corey Richens case and like, why would the prosecution bring these extra 26 counts? Because once she's sentenced on, the homicide and attempted homicide, does it even matter if there's more time? Well, in Utah, the parole board will decide how long a sentence is generally. And so you want them to consider all of the behavior, and the additional charges fit and will in part go to all of the behavior needs to be considered for her down the road. The state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. We talked about this in the Emily show, I believe this week, where we talked about whether Bryan Kohberger could earn funds or could earn money if he sold his story or rights to his story or rights even to his name, image, and likeness for people to tell his story. we might see that down the road. And on Monday on the Emily Show podcast, I broke all that down about what that looks like in Idaho, the history of some of those laws, and how those laws and the First Amendment have kind of a rough tension with each other. And so in Idaho, any funds he would receive regarding his story or from outside sources would go into a holding account by the state. And then victims' families can make claims really against that fund. Defendant understands 1A, the nature of the charge in which the defendant agrees to plead guilty and acknowledges that he is not being coerced into entering his plea of guilty. He will acknowledge and understand and acknowledges the consequences of pleading guilty, including the maximum penalties that may be imposed and any mandatory minimum penalties. And this is standard language. This is just boilerplate language. And that C, by pleading guilty, he waives his right to a jury trial, to confront accusers, to refrain from incriminating himself. Because he's incriminating himself by pleading guilty, he's saying he's guilty, so he's waiving his Fifth Amendment right. Defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses. I mean, all. Can we talk? They explored all possible defenses. Is there any question that every possible defense was not explored? And by his plea of guilty, he is voluntarily waiving those defenses and all claims based upon his constitutional rights. You don't get to argue you didn't have a good lawyer. You don't get to argue that this is cruel and unusual. You don't get to argue that you have a Fifth Amendment right not to plead guilty or not to incriminate yourself. You don't get to argue all these things. Defendant understands that if we're to proceed to trial, if we're to proceed to trial, he would have the right to appeal, including but not limited to A, any issues decided by the court prior to the defendant's guilty plea, including any ruling on the admissibility of evidence, B, the judgment, including the finding of guilt, and any issues regarding the guilty plea. It would be the guilty finding. That's a typo. And C, the sentence. Further, the defendant understands that, is that typo actionable? No. Further, the defendant understands that we're missing something there. If we're to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of the sentence. The defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. He's waiving all of his appeal rights, waiving his right to seek reconsideration, his right to seek a reduction, waiving any of it. This is the entire agreement and understanding between the parties. What I prefer is that if there's still room to write, you put like a line down here or something, but it's fine. It's a matter of preference. So that is the plea agreement that is now memorialized, on the docket. That was given to the judge before the plea hearing that we watched. And this will be, it's on the docket. Let's go through what I have seen widely referred to, and I agree with the characterization of the signed confession. This is what we heard in court, and we're going to go through that now. This was not signed by Bryan Kohberger, it seems, until July 1st. The other one was signed on June 30th, so this was done afterwards. This basically lines out the plea and the indictment. So this is the indictment. And this is what we saw the court read in when he pled guilty, because he said yes to each of these steps. And then he's also, I plead guilty to counts 1, 2, 3, 4, and 5 of my own volition is what is listed here. So this is him saying, these are the things that I did for me. I hereby admit responsibility to count 1, burglary, which requires the following elements. On November 13th in Latah County, state of Idaho, the unlawful entry of a residence located at 1122 King Road, with the intent to commit the crime of murder. I think this is the first time we have seen them really line this out as intent to commit the crime of murder. In the past, it has been with the intent to commit a felony, I believe. So they line that out very specifically. And then we get through each of the counts, which are the same except for the victim's name. And as to count 2, I hereby admit responsibility to count 2, murder in the first degree, which requires the following elements. On November 13th, 2022, Latah County, state of Idaho, the willful, unlawful, deliberate, with premeditation and with malice aforethought, killing and murder, it should say of, I think, Madison Mogan, and then the same for Kaylee Gonzalez, and the same for Xana Kernodle. I always read that wrong in my brain the first time. And of Ethan Chapin. So each of those are the same, and those are all signed as of July 1st. So I'm grabbing a lot of your questions. If you give me 1 second, because you guys have some great questions and I want to get to them after we get through the documents. So I'm holding on to those real quick. All right. We are going to get to the next document in this, which is the prosecution's written factual basis. Let me grab that real quick. So the written factual basis is what we saw oh no, this is the wrong one. What the prosecutor read out in court. Where is that? Did it disappear? I just had it. I could have sworn I saw it. No, maybe it's gone. Wait. Now I sound like the Crossman's show this year. Wait. I could have sworn it was up here. I do not see it though. I see the plea agreement. I see his signed. I do not see the written out one from the prosecution. Though we have covered so much lately, that might have just been me, but I thought it was here too. For those of you who are like the Crossman, I know they're doing one called Crosswalking, and they have the crosswalking noises throughout the show. And it's been intrusively stuck in my head, the crosswalk sounds, just stuck in my brain. I don't see it. I thought it was here, but I do not see it. I will keep looking for that because I could have sworn it was here, but I also could be completely wrong because we've got the plea agreement that we went over on the factual basis. Those might be the only two. I thought the prosecution's proffer, technically, because this, when I'm talking factual basis, this is what the court calls the factual basis, where Bryan Kohberger is admitting not just to each of the counts, but admitting to the elements of those counts, including the willful, deliberate, unlawful, premeditation, malice aforethought. He's admitting to all of those things. That's what the court calls the factual basis, vis-a-vis the prosecution's proffer, which is their statement of if this went to trial, the evidence would show. I thought that was also posted. I might be wrong. So I'm going to zoom us to the fights over the gag order, non-dissemination order and gag order were just fighting in my brain. But we're going to go through those fights. And if I see it, we'll see it. Dark Square, yes, that was the one where we saw him get a little bit emotional about the things. So it's just, we can go back through that another time if we need to. I thought it was written out, but it's not where I see it. I'll go look and see if I can find it. But it might not have been filed, though the factual basis would have to be agreed to. The statement of the prosecution says we believe the evidence will show does not have to be agreed to. So it might not have been filed, and it might have just been the title that threw me off. All right. We have a memorandum to be heard as interested parties, a memorandum in support of motion to be heard as interested parties, and then multiple declarations. We're going to go through all four of those together. This is the media, again, interceding or asking to intercede in this case. I don't know if the judge will even acknowledge this. Like, I don't know if he will. I can't judge this one over because I'm grabbing it directly from the website. So it's not in Google. My brain is clearly, Emily, how you doing? My brain is stopping. Went to the doctor yesterday about the knee, but it's getting better, but it's still making it a bit hard to sleep because it hurts. So we are not as well slept as we would like to be. Let's do this way. See if we can zhuzh it over that way. All right. I can't wait to have my own streaming software. Motion to be heard as interested parties and motion to vacate non-dissemination order. This was filed on July 3rd. This has not been talked about much, but the court has not addressed it. It just popped up onto the docket. This docket populates late. Ugh, let's talk about what's difficult with Idaho during this case. This docket populates late. When I go to grab dockets from other jurisdictions, often they are paid and you have to register and have access. Some jurisdictions, if you're not a lawyer in the jurisdiction on the case, you just don't have access, or you have to be physically in person to have access. But a lot of jurisdictions, you have online access or can have online access to go and grab court documents, and they charge a wildly varying amount depending on the case. But Idaho does not easily allow for direct access to the docket. So they made a cases of interest or a high profile cases page. A lot of jurisdictions do this when they have high profile cases and everybody is trying to grab documents from them. I think it's probably easier on their whole system. And they do provide them for free. 10 out of 10. I think it's better access. I understand why other jurisdictions are like, we have to maintain this website. You're paying us for these documents. Enjoy paying 50 cents a page or whatever it is. But Idaho provides them for free. But it's a delayed docket. So when things go onto the court docket, they go into the court docket, but then they have to be processed and manually placed onto this website. And there is some tension with that because it is delayed. And there's no access to, oh, this just got filed today, because you don't see it for a couple of days. So things are not timed as easily. However, they are free. So there's that. Marissa says, sounds like Massachusetts. Massachusetts, you have to be in person in the state to go grab them. But yeah, it's delayed, which is frustrating. Let me grab. I saw another question I want to grab. Give me one sec. Nope. I did not grab. Oh, there it is. Okay. I'm holding things for Q&A because we're going to have time for Q&A today. I'm putting it out there. We're doing it. No, Emily, not the time. Motion to be heard as interested parties and motion to vacate non-dissemination order. Remember, the court said at the plea hearing, can I vacate this now? And the prosecution said no. And the court said, okay, this will be vacated at the time of the plea. The time of the plea is next week. It's a week from now, isn't it? 2 weeks from now. Okay, that's a little longer out. So the plea is 2 weeks from now. I don't know. Is there anything that can't wait 2 weeks? I just don't. I don't see things the way that legacy media sees things. But I also know that we can talk about things when we choose to talk about them. I am not going to, go banging down people's doors to be like, hey, do you want to talk to me? I am not a journalist in that way. I feel like I am a commentator. I report on the things that have happened in court and in the documents, but I am not sending someone to Idaho or wherever to go knock on doors and be like, hey, do you want to talk to us? I don't love that. If people want to talk, they generally know where to find you. And I kind of feel that way about what I do here. Like, if people want to talk to me, they know where to find me. They know where I am. And they do find me. People will send me, most of them, like, hey, I just want to let you know XYZ. Perfect. But I get the sense that more legacy media wants to probably have access to law enforcement investigators, the defense private investigators, like the defense PIs can talk. The lawyers might never choose to talk, or they may. But I don't think it's the lawyers particularly that they want to get to. I think it is all the auxiliary individuals, law enforcement, FBI, private investigators, etc. And until this fairly broad non-dissemination order is lifted, they can't do that. And they want to. I don't know. I think they're like, interest is now. But the press also has a tension with, we're the press. It's our job to run down stories. It's our job to find the story and let people be heard. And I imagine there's a lot of them where their programming directors are going, oh, but we had blocked out months to just cover this. Like the amount of programming I'm sure that was in the works have people probably shitting themselves because all of that is just gone. Trials are dynamic. There will be another one, but they are fighting for attention. And I see this as we can't wait 2 weeks. Let's hear what they have to say. I do appreciate it though. In numerous cases, sometimes this is the only way we get access to stuff. So did I say the plea hearing? I mean sentencing. Apologies. I mean sentencing. Sentencing in 2 weeks. If I said plea, I apologize. So these are all the different media entities that have joined in with this. The attorney on this case, we're going to just go to the bottom real quick, I think is still the same attorney. Yeah, Wendy Olson is the attorney in the defamation case. And so with the defamation case, we will see also the work by Wendy Olson. Same attorney, different case. No, it's not a conflict because she is representing the interested parties, which are all these media outlets. On July 2nd, 2025, they say Bryan Kohberger pled guilty to the murder of 4 University of Idaho students and 1 count of burglary. Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case. Agreed. There is no real balance left of not tainting a jury pool. There will be no jury pool. There is no jury pool left to worry about. There is no right to fair trial to worry about. The fair trial has been given and is done. At the request of the state, and with the agreement of Kohberger, the court left the non-dissemination order in place until Kohberger's sentencing, which is set for July 23rd. However, they say the non-dissemination order and its infringement on the First Amendment rights of the media is no longer justifiable and should be vacated immediately. Accordingly, a coalition of media organizations, including ABC, the AP, Bonner County Daily Bee, CBS, Coeur d'Alene Press, East Idaho News, Fox News, Idaho Press Club, Ion Media Networks, DBA Court TV, KXLY, TCP Holdings, Moscow Pullman Daily News, and all the other alphabet soup that's going in there, including the Idaho Statesman, etc. There's a footnote on all of the media coalition. The media coalition is largely made up of the same media organizations that were allowed to previously intervene in the non-dissemination order and were granted an opportunity to be heard on other issues related to media access. These organizations once again seek to protect their First Amendment rights. So, big coalition of media. Hey, Your Honor, do this. There's lots of us saying you should do this. They respectfully move the court for leave to file their motion to vacate the non-dissemination order filed contemporaneously herewith. Remember, the court has to say, hey, you're allowed to be heard. They don't just have the right to be heard. And they are not a party to the case, but they have a First Amendment right. And so we will see the media pushing back for transparency, which I appreciate. But there are times when I think the media pushes too far, and you'll hear my criticism of that then. I think saying, hey, we want to be able to do our interviews, there's no rights left to be protected. So when the court balances those rights, the defendant's right to fair trial, he is foregone because he's pled. So, continuing on, they say the media coalition further requests the opportunity to present oral argument on the... No. You don't need oral argument on the thing. Ugh. Stop it. You just need the motion. And I don't even know if the parties are going to oppose the motion. The parties are going to hope that the court just puts this over till after the sentencing in 2 weeks and then lifts it then. The media wants to garner the attention in the next 2 weeks because this is what people are talking about. I think this could be done on written motion. The motion is supported by accompanying memorandum, the declaration of Rebecca Boone and Wendy Olson in support. And we're going to look at all of those things now. So let's move on to the written motion. The balancing test considerations have changed. They are asking to be heard as interveners. This memorandum won't even be addressed by the court unless he grants the motion to intervene. He might not. But the one thing I will say that has struck me about Judge Hippler is I do see him as a judge that's like, the law's the law. The law's the law. And okay, the parties might want the non-dissemination order, but the parties can't infringe on the rights of the media just for vibes. Your Honor, can we just leave that in place? Okay, well, sorry, Mr. Thompson, if your email is unusable for the next few weeks, but Bill Thompson is the elected district attorney in Latah County. I imagine that his email is already quite unusable because I imagine that there are many who have, after the court said, I'm not the right person to talk about or to talk to about your displeasure with the plea, I imagine that there's a lot of people that went to the elected DA, Bill Thompson, and went, So I understand that the attorneys don't want to be pestered for interviews. The office of the district attorney has the option through a representative to say, we are not speaking on this case until after the sentencing. Don't email us. I mean, it's kind of part of the job. Back in my day, we had a media relations unit. And so when I had cases that had interest, I would be like, hey, this is the email to media relations. This is the phone number to media relations. I'm not talking about an ongoing case. Go talk to media relations. And that was it. So somebody's job is this. And just because you don't want to be annoyed, I mean, it's a reason I make decisions in life, but you're an elected official. You don't get to just be like, hey, I don't want that pesky press bothering me. I don't like the way the media hyper-sensationalizes things. I don't like that every case has some graphic title. I don't like it. But they have the right to seek interviews at this time because the balancing test of Bryan Kohberger's interests and their interests change. And when that balancing test change, I don't know if you can sustain this. It's just interesting to me that they're like, immediately no. Immediately no. This is the memorandum in support. Let's see what they are saying. Media coalition versus everybody. No, they're not versing anyone. They're like, excuse me. We'd like to be heard. Please let us in. Open. On July 2nd, Bryan Kohberger pled guilty to the murders of 4 University of Idaho students and 1 count of burglary, which caught everybody off guard because this broke on June 30th? And then he pled on July 2nd. It was so fast that I'm sure the media didn't even have time to figure out what they're doing next. Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case. Mr. Kohberger will never face a jury to determine his guilt. Right, he admitted to it. Nor will a jury have any role in determining whether the death penalty is the proper punishment. All that remains is for the court, not a jury, to impose sentence. But even then, the parties have waived a pre-sentence investigation, and Kohberger has agreed that he will not argue for anything less than 4 consecutive life sentences. Oh, I added that word. Anything less than consecutive life sentences without the possibility of parole. Yeah, he agreed that it's like max. Like, he's being sentenced to all. Even before Mr. Kohberger was arrested, the court entered and has enforced a non-dissemination. Really? I don't remember that. I thought it was after he was arrested. Huh. Even before Mr. Kohberger was arrested, the court entered and has enforced a non-dissemination order restricting the individuals involved with the case from making extrajudicial statements. One of my least favorite words to pronounce, out-of-court statements. Footnote 1. The court non-dissemination order is the third iteration of such an order. The court first imposed a non-dissemination order on January 3rd, 2023. No media members were heard on the first two orders. Following a hearing in which many media outlets were represented by undersigned counsel, the court entered the revised, amended non-dissemination order on June 23rd, 2023. These non-dissemination orders have been predicated on a singular justification: preservation of Kohberger's right to fair trial. Accurate. But Mr. Kohberger's change of plea and the terms of his plea agreement have rendered that justification moot. I don't disagree. In fact, we know that the court agrees because the court said, "Can I just lift this now?" And the prosecution went, "No, sir." But the justification isn't you don't want emails while you're getting ready for this. And if it's overwhelming to families, which it may be, they have the right to, I don't know if they want to ask the prosecution for anything, but the prosecution can say in a statement, the non-dissemination order has been lifted, but these families and the prosecution will not speak to the media until after the sentencing. You can just put out a statement. Will the media respect that statement? I mean, unlikely, but they have rights too. We are a country that is supposed to be governed by rights. So the media has a right, a protected free press right to go track down stories. And Kohberger's rights at this point have all been waived. He pled guilty. All of those other rights are gone. He still has like his Eighth Amendment right, but you know what I mean. All of the rights that are concerned here, all of those rights are done now or moot. Indeed, at the conclusion of the plea hearing, Emily, keep reading. At the conclusion of the plea hearing, the state said that it opposed the court's suggestion to discontinue the order because it would be easier for the parties in preparing for sentencing. All of the keep reading. Were you guys reading ahead while I was soliloquying? Probably. You were like, girl, they're going to say that. They're going to say that. The non-dissemination order is now plainly overbroad and therefore runs afoul of the First Amendment. Accordingly, the Media Coalition respectfully requests that this court vacate the non-dissemination order immediately. Argument: the non-dissemination order should be vacated immediately because its sole justification no longer exists, and thus it impermissibly prohibits free speech. And then they're going to go through the case law that has the balancing test of different rights. They go on to say in a footnote that the Media Coalition is made up of the 24 media organizations listed in the caption. The non-dissemination order is no longer justified by the need to preserve a fair trial. By its own terms, or like in contract, well, you said this is why it's needed, and that's no longer true. By its own terms, the non-dissemination order is moot. The non-dissemination order provides a singular justification for its restrictions to preserve the right to a fair trial. Kohberger has pled guilty. He waived his right to appeal. There is no possible set of circumstances under which Kohberger will ever face a jury to determine his guilt or determine whether the death penalty should be imposed. Yes, it is what the families, well, some of the families, I shouldn't say all of the families, it is what some family members have expressed their displeasure with. But yes, that's true. No trial will occur. Thus, there is no need to preserve Kohberger's right to a fair trial because he already admitted guilt. Footnote 3. Indeed, it appeared that even the court saw no reason for continued enforcement of the non-dissemination order following the change of plea until the state requested it remain in effect until after sentencing. Right. The prosecution's relative annoyance is not the reason. Moreover, the effects of the non-dissemination order are more than collateral on the Media Coalition's First Amendment rights. Non-dissemination orders, they say, strip journalists of a crucial tool for informing the public and exercising their First Amendment rights. And then there's a declaration attached. They say, although the gag order, this is citing from case law, People versus Sledge. Sledgehammer. Emily, we can't start singing because what you can't do today, half of my brain is like, okay, I know that my knee, truthfully, also hip, are giving me all the business, but it is Creek End. And like, Indy's not that far away. The challenge of a fan when bands play, like, if you just went to Creek End, would it be that, like, you can get there? Like, would it be difficult to just go? Could we just, I mean, I could just grab like a lawn ticket, like, So as we get into sledge, I'm just like, Emily, stop. Olivia said, Creek End sounds like my knees after weekend hikes. It sounds like my knees too after weekend shows. And also my knee is relatively fine, just pissed off. It's going to take a little time to get it unpissed off, but it's nothing that's more serious than that. But I don't know if I could even do all of the Deer Creek stuff. But this is where my brain's at. But I could just, but also I don't want my knee to crap out before I go see Travis perform because like stadiums, lots of stairs. Continuing on. Where were we? People versus Sledge. It's the case name that's the problem, not me. I'm teasing. Although the gag order does not directly prohibit media from discussing the case, it prohibits the most meaningful sources of information from discussing the case with the media. It has long been recognized that the media acts as surrogates for the public. What if we no longer want them to be our surrogates? Do we? I would like a say in this. You do not speak for me. My dog speaks more eloquently than the... I'm sorry. It's just going to be that way today. The ADHD is ADHDing. They go on to say, in a society in which each individual has but limited time and resources with which to observe at first hand the operations of his government, he relies necessarily upon the press to bring him in convenient form the facts of those operations. What year was this written? What year is this quoting from? Cox Broadcasting versus Cohen, 1975. Does anyone feel like this is true? I want this to be true. Lord knows I want this to be true. I want it to be true where we can rely on the press to bring us facts. Can we go back to there? Can we go back to like reporting? Hey, in court, this thing happened. That's it. You know what? I look to local media and independent accounts for that because I really appreciate it. It's like in court, judge said this, party said this, lawyer said this, somebody said this, and that's it. I rely on local media for this. I generally don't rely on national media for this anymore. I would like to be able to. I would really like to be able to rely on these are facts. I really do miss it. Okay, more so. That's why we fact over here. And then when we fuckery, I tell you, I am speculating. This is what I think. Wouldn't it be funny if this is what we're seeing in court? All right, more so, it continues to say the free press is the guardian of the public interest. Excuse me, press, can you go back to that? I have a lot of questions right now. Can we ask them? And that's from 2012. One of the most basic rules for fair reporting is to seek comment from the subjects of a news story. Offering subjects of news coverage. I mean, I don't want to hear from Bryan Kohberger. I'm sure many do. Is that what the media is trying to get at? Because what other subjects are there? The families of the victims can speak. The witnesses can't, though. The witnesses are still covered by the non-dissemination order. I don't know if the witnesses want to speak. And if the witnesses do want to speak, unless they're being offered quite a lot of money by legacy media, I wouldn't trust your story to anyone but you. It would be my advice. It's your story. You have the right to control it. If there is a monetary benefit for you, go ahead. But No one needs the media. If one of the surviving roommates, this is just an arguendo. If one of the roommates wanted to tell their story, would they be better served in the hands of a media company that would edit that story? Or would they be better served putting up a video on whatever platform they choose and saying, this is what I have to say about it? And it is what it is. I don't know. I don't know how they would feel better served. But my advice would be, unsolicited advice. My unsolicited advice from Emily is, if you are choosing to talk to media and people that you trust, find out how they are going to edit it, ask to see it before it's released, and try to maintain some control over how your story is presented. It is yours. That would be my advice. Or put out a written statement and give it to all the outlets at once. Or if there is a particular person you trust that does long form conversations, go to that person, not their outlet. But you are in control. You do not need pick 3 letters and put them together to tell your story if you choose to tell it. And if you put out a written statement, put out a written statement. There are local news like East Idaho News that have done incredible work. There are independent journalists like Brian Enton. Well, he's with News Nation, but I see him more like a independent journalist. He operates more that way. JB Buno at WFLA. There are journalists, if you like their coverage, go directly to them. So Katie B says, Amazon has the roommates in a documentary, I believe. I don't know about that. I will look, Katie. I'm not questioning you. I don't know about that, but they are covered by the non-dissemination order. The court's already salty about this, but that is my advice. Or you can have someone draft a statement with you and for you and just put it all out. You also have the right to not say anything. No one needs to, dive into all the details of one of the worst things that's ever happened to people. You have the right to keep that shit private for as long as you want. And you have the right to change your mind later. So, Jen said, can they keep the order in place while they investigate the leak? No, they can't. Because it doesn't meet this balancing test in the law. Investigating the leak doesn't impact Bryan Kohberger's rights at this point, right? Jay said, Emily, I'm kind of confused. Are you pro-journalism or not? No, like most things, there are some things I like and some things I don't like. I think we need journalists. I think we need good journalists. I think there are good journalists. I think sometimes who they work for can override them. And I've seen that a lot where a producer, an interviewer, they might all see a story one way, but then in larger media outlets, what they've created goes off to a million different people to edit in different ways, to chop up in different ways. And then they don't always have the control and say over the final product. And that can be a really difficult thing. When you have shorter form, everything's clipped down to like a 30-second, 90-second snippet, it's hard to have cohesion. And so it's more of a pick who you trust and have realistic expectations going in and ask more questions than you think you need to ask. And don't just trust that if you sit down for 3 hours with somebody, what you've said is going to be represented the same way. And make sure that you understand that. It's something that not everyone sees and knows. So I think there are great people that do great work. I just think that gets harder and harder to parse in the way that media is presented, which is what I love about a long form podcast, a sit down, this isn't edited, let's roll. And there's so many more of those formats now that I really appreciate it because it is what it is. Sit down and have a conversation. It is what it is. So I appreciate that. So it's, eyes open, make the decision or don't. That's where I'm at. So yes, we need journalism. I don't love all the ways that media has changed into shorter and shorter sound bites and sensationalism. I don't love that. It feels like it's constantly pulling at people's attention, and that I don't love. So it gets hard to fill 24 hours. Emily, are we going to have a dissertation about the 24-hour news cycle? Not today. But it is something I do quite a lot of reading about, because how it changed the way media operates and how we got to like here is so curious to me. But I do think there are good journalists out there. And I think there are people that present things well. And I think there are people that embrace a longer open conversation to just show you what's happening versus clipping things mid-sentence. If you didn't watch my video, we'll link it. Miguelina's like, what are we going to link? We'll link it. But I did a few videos on an interview that Amber Heard gave. I think it was with ABC. With Savannah Guthrie. I think that's ABC. I don't remember. I think that's ABC. And I've worked with ABC a lot and really like a lot of the producers at ABC. But we looked at the clips that they showed as like teasers. And then we looked at is it NBC? And then we looked at the ultimate interview. Sentences were spliced like mid-sentence. And it blew my mind. Like, we have seen Real Housewives complain about this for years. Emily, we're now on a soapbox. We have seen Real Housewives complain about this for years, and sometimes they just use it as like, it wasn't me, and when it was, and sometimes it might be fact. They're like, I got a really dirty edit. In the Jen Shaw case, we talked about the like Franken editing of sentences, of events, and you can see it sometimes if in the rare event that anyone's eating, if they go to dinner, you can see that a sentence is here and a sentence is there, and there's plates on the table, then there's no plates on the table, and then the plates are full and then they're not full, and then drinking glasses are full and then they're not. And you can see a lot that conversations even aren't flowing in order. But in that interview, they had released previews of like teasers of the interview. And then when the interview came out, the sentences were different. And it was very hard to perceive the cut if you hadn't seen the teaser. I find that incredibly disingenuous and misleading. So those are the types of things that I just hate. Hate. But if you watch that episode, I was like, you've got to be fucking joking me. Like, it said this way. What is happening? So let's continue. I know Serena said, girl, they do it all the time. I know. And half the time we can't perceive it because we didn't see what the source material was. Which is why I'm so much more a fan of, we'll just do it all live. We'll just do it live. It has its pluses and minuses. Some days are much more smooth than others, but we'll just do it live. So that I found very frustrating, truly. Just Raina said, can someone sue for misrepresentation if they do that? Not in this context that I was just giving. This is a great question. Not in this context if they do it, because in the context of the ABC interview, this is purely my speculation. But can I imagine a world where lawyers and or the interviewee saw the initial clips and went, ooh, that looks bad for me. The internet's going to lose its mind. Can you change that? And then they did. That would have been assented to by the person doing the interview. Also, a lot of times when you are signing your rights for the interview, you sign off on they can edit it however they want. You sign off on you can't sue them if the way they edit it is defamatory. I mean, I don't. But it's in those contracts that you can't sue them if the representation is unfavorable or defamatory or whatever. Like the things that you sign away in those typical contracts, if people are signing them without their lawyers raising hell, is pretty substantial. And if we're talking about reality TV reality TV signs away everything. Reality TV can't, I mean, they can complain about the edit, but they can't legally complain about the edit. And in reality TV, if they create, like on Drag Race, if they create a look, a persona, that's not owned by them. That's owned by the network. On Housewives, if they create a brand or a product or a catchphrase, that doesn't belong to them. Like Denise Richards, and if you guys are interested, we might get into the divorce of it later. Denise Richards, I think it was her first season where she had that whole moment where she's like, bravo, bravo, fucking bravo, like cameras down, I want to talk to the producers. And they're like, girl, this is reality. That's not how it works. Bravo still sells merch that says bravo, bravo, fucking bravo. Do they have to pay any of that to her? No, because she signs away the rights for all of it. Bethany Frankel always talks about how they call it the Bethany Frankel call. They call it the Bethany Frankel clause because she created her Skinny Girl alcohol brand that is morphed into a ton of different things during the time that she was on Housewives of New York. But they didn't have a clause that they owned a part of her brand. Now they do, but they didn't have a clause in there. So Bethany was the only one that scooted away. And that's because it was so early on that they didn't even realize, I think Bravo didn't even think about, what if somebody uses this as a platform to launch a thing? Then what do we get? So I would imagine, and again, this is speculation, from what I know of reality TV contracts, that even when like Lala had the Send It to Daryl merch, that Bravo is still entitled to a cut of that. And do you want the real tea? When you go to something like a BravoCon, there's like an aisle where, or two, where everyone in the Bravoverse can sell whatever thing they sell, whether it's a t-shirt, a whiskey, a vitamin, whatever it is. Emily, why don't you get invited to Bravo things? This is the reason. This is the reason. Emily, why? This is the reason. They have to pay for the booth first. You can't bring in your own things for the booth, so you have to rent from the hall, wherever it's being held. You have to rent the booth space, the booth, the tables, and whatever else. So all of the physical structures you have to pay for to generally the hall where you're having the event. And I get it, because the location and the venue are going to have their own lawyers being like, you can't have people just like loading in tables and chairs and whatever else. Like it all has to be approved by us and rented through us. Fine. But then the event takes a substantial percentage of the merch that's sold. So even if you're bringing in merch that you've paid to create, merch that you've paid someone to change. Julia said it's convention exhibition rules. Yes. 100% yes. So the merch that you are selling, BravoCon gets a substantial cut of it. And I saw this change from the first year I went to BravoCon to the second. So I went to New York BravoCon and then Las Vegas BravoCon. And I'm just like, how is this? Like, the Housewives are so generous with the conversation. And we were there for setup day. I ended up building tables and trying to help people get their POS systems online with friends. I was like, oh, it's like everywhere I've worked ever, it's like, can you fix the copier? So I was trying to help people get their POS systems online, point of sale systems. And what I learned is that in the year, was this the second year of Vegas? I think it was the second year of Vegas, that the POS systems were all brought in by whoever was running that part of the event for Bravo. So each vendor couldn't have their own POS system. So it seemed to me that the POS systems were keeping track of the sales to make sure there was a proper accounting, to make sure that they got their almost half of the profits. So if you're looking at the Bravo Leb coming in to sell their product that they have paid costs for, they have paid shipping to get there, they have paid someone one would hope, to be at the booth for the whole day to sell it, and then they only get a fraction of the purchase. I imagine most of them were breaking even at best, if not taking a loss. And it's a why, and then the cost of the booth. I was like, for real? For real, for real. And then the rebel part of me is like, you guys should just bring enough product to like show it and then sell it online. But selling it online then comes sometimes with shipping. And if people are there and they want to buy it and take it home, they will. But then the second year of Vegas. So I went to New York, Vegas. The second year at Vegas, Bravo had massive merch booths with phrases from the different housewives and whatever. They had massive merch booths. And so the merch booths from the Bravo Lebs got kind of pushed back a bit on the floor. And Bravo was highly incentivizing their merch. So it seemed like the talent booths were not as well traveled just because they were a little bit more off the beaten path. And so people were doing meet and greets there, which Bravo also got mad about because they're like, you know, people are putting on social, like, I'll be at my booth at this time, so I'll sign your merch or whatever. Because now they're like, okay, well, what's the benefit of coming to buy it from me? And then Bravo was getting salty because Bravo books them out for photo ops. And you have to like reserve tickets in advance for photo ops. It's like a full con for people who con and go to cons. Convention. NBC execs are like, this is why she's on the no-fly list. And so Bravo talent was like, oh, I'll be at my booth signing your shirt or whatever. But Bravo was like, no, we sell tickets and sign people up for the photo ops, meet and greets. You can't just be at your booth. I imagine that'll all get shut down by the next time they go to BravoCon because some of it does create ingress-egress problems because if there is a popular Bravo Leb by their booth, like out in the wild, it creates that huge crowd and then there's no ingress-egress at all. So I get it, but also I get where the talent is like, we don't get paid. Oh, this is probably T2. We don't get paid a ton to come to BravoCon. Like travel gets accommodated for whatever. The work days are hellaciously long. I can't even. I can't imagine being in like full glam and sky high heels by like 6 a.m. as a call time and not being done till like 1 or 2 a.m. They're like longer days than DCI days. But then often they bring their teams with them. And depending on where they're traveling from, they're paying for their hair, makeup, glam assistant, whoever, to fly with them and then paying for them to stay. So I think most of them take a loss on traveling to BravoCon is the long and short of it. But the reason they bring merch is because shipping gets expensive. And so if you want people to have merch because they are a fan of you, bringing it in makes more sense. This is way behind the scenes of baseball. So it's very much how did we get there from here? I don't even remember how we got to BravoCon from talking about this, but it becomes a huge thing. Back to what we were talking about, which is the media. It's probably how we got here. Declan said, as someone who has worked other conventions, this is wow. The behind the scenes is so different than the conversations I've worked, or the conventions I've worked. I'm sure this happens with convention, like food vendors and stuff. It's attention. There is attention. There is attention here. So getting back into the media wanting access and me soliloquying about anyone can have a mic and a camera and a phone. You can share your story how you want. So the reporters in their argument are saying one of the most basic rules for fair reporting is to seek comment from the subjects of a news story. That's how we got here. CEG, my last soliloquy. That's how we got there. Offering subjects of news coverage the opportunity to comment or respond to criticism or allegations of wrongdoing is a core part of journalism codes of ethics. Which subject of news coverage can't you talk to? You can't talk to Kohberger. You can't talk to the witnesses. You can't talk to law enforcement. You can't talk to the attorneys. You can talk to the victims' families. And that's about it until this is lifted. Seeking comment and insight from the people closest to an event or news story allows the media to provide context, convey diversity of opinions. The media does that. Give a voice to the voiceless and hold the powerful accountable, or hold the powerful to account. Emily, you have so many questions. You have so many questions. We're going to keep going. Thank you, Wendy Olson, for making your arguments. Nicholas asks, you think they want to try to talk with Kohberger? Yeah, I do. Yeah, I do. I don't know if they will, but I think they want to talk to Kohberger. I think some of this reads as they want to talk to Kohberger. I think they probably also would like to talk to his attorney or his PI, like whoever the defense PI is. I think they want to talk to too. Okay. There are no other legitimate justifications. No, yes, justifications for continuing enforcement of the non-dissemination order. Yeah, the justifications are moot. I agree with that. Jill said, would Kohberger even talk? They have no way to know because they can't ask. I hope not. I really hope not, but they have no way to know because they can't ask. There was no other legitimate justification for leaving the non-dissemination order in place. At the change of plea hearing, the state justified its request for the continuation of the non-dissemination order by claiming it would give them space to prepare for the upcoming sentencing. I don't think that's what happened, by the way. I think that they objected and the court said, is it because of this? And they said, like, yeah. Peapot Fairy said, Idaho doesn't allow prison interviews. I appreciate that. I don't know if Idaho could stop phone call interviews like they have done with, I don't know, Suge Knight often will put recorded phone calls out as a like podcast format. We've seen Anna Delvey, before she was released, give interviews over the phone. So even if somebody can't come into custody, if someone has phone access, they could still phone access. You could also still have conversations with the lawyer conveying. You can also still have writing. You can also still have, well, often texting. So even if you can't come into the custody and sit down with someone face to face, there's other ways. Brianna the Blonde Dispatcher, thank you for the work you do. So was Lori Vallows not from Idaho? She had an Idaho case, but she's now in Arizona custody. So she was able to sit down with Nate Eaton because she's in Arizona custody, not Idaho. No. So still in Arizona. They go on to say the media coalition has been unable to locate any authority that supports the notion that providing an attorney space for media requests is sufficient to justify the imposition of a non-dissemination order. They're right. The relevant authority provides one justification for this type of free speech restriction, the accused right to fair trial. They're right. Legally, they are right. And I understand the timing of like, we can't wait 2 weeks. In my world, I'm like, I mean, he's not going to be sentenced for 2 weeks. Can I go to Creek End and then get to see DCI like 4 times? Like, do I have time? How much time do I have? My brain works differently. That's why you're here. Conclusion. Simply put, the non-dissemination order no longer serves the legitimate purpose. For the reasons stated in this memorandum, the coalition respectfully requests that this court grant its motion. It might. The court might grant it, but I can also see where legacy media is like, this trial's not going. We've got 2 weeks to get the story. I couldn't do it. I couldn't do it. I could. The relentless pace of media is something I just can't imagine. I can't. And I'm also not, quick story time before we get to the we're doing lots of behind the scenes today because we haven't had a lot of time to chat. We've been in trial for so long. before we get to the Wendy Olson declarations and then get into our next topic, when I went to one of the Britney Spears hearings, after the hearing, she was not present. It was all the lawyers. As the lawyers were trying to leave, and you guys, if you've watched any of the out of court coverage, like the outside the courthouse coverage of the Karen Reed case, and you see Karen Reed in this teeny tiny little bubble and everyone with a camera, a microphone, and people like reaching over each other with microphones to put them in somebody's face. The crushing crowd of that was so uncomfortable to me. And I'm like, oh my God, the personal space. But as we were leaving the hearing, I had asked a couple questions of James Yeated Spears' attorney. And he was standing in an area where nobody was like crushed up against him. But then as the attorneys were trying to leave, the media was walking, and mostly I screwed up my autofocus. Most notably TMZ was walking backward in front of him. So you couldn't see where you were walking forward because there were so many people in front of the attorney trying to get to the parking lot that they were walking backwards, like up the stairs with their phones literally in his face. I don't know how you don't, and I understand every time I see celebrities like pushing a camera out of the way, I'm like, oh, I understand better. But it was so invasive of the personal space and then just shouting questions. This is not anything I would be good at. This is not for me. I can't. Horrible. And he was carrying he had no hand to like move people out of the way. And he's carrying a box of casework, trying to get up the stairs to his car saying, I don't have anything to say about today's hearing. And it's phone in face shouting questions. It was wild to see in person. And it always made me uncomfortable watching, even as Karen Reed was trying to leave court. And she seems like a more petite woman in person, but she even looked like she was pulling her shoulders in because of how much people were crushing into her space and handing cameras over the side and pushing into her face. It's so uncomfortable. Like it's just so uncomfortable. Anyway, so I could never, but it's wild to me. So let's continue on. This is why I love a long form. For sure. That's true. Lyndon said, then you have Gloria Allred in New Mexico. Hold this for me, as she tells the reporters. Yes, she was like, I've got it. But the like elbowing people out of the way, like I did that in water polo and open water swims. I don't want to do that anymore. And I think everyone finds the flow that works for them, because I'm sure some people love the adrenaline of that moment. Not for me. So Sarah JD said, the way I'd be throwing elbows and breaking thousands of dollars of equipment. I know, it's wild. I like it when they set up like the microphone array, and it's like, okay, here's the microphone array. We'll all be here and you'll be there. It's very orderly. Emily, weird. You like order. So strange. So strange. All of you are shocked. It's like, oh, look, order. Let's take a look at the declarations. These are a first look for me. I don't know how much information we will glean from them, but the media wants the non-dissemination order yeeted so they can interview whoever they want to interview. All of you who are like, I would start throwing hands, I get it. Also, I would probably just start singing Disney music. It's like, good luck with copyright. Just start singing Hamilton or something. Why is she singing The Little Mermaid? I don't know. Weird. All right. This is from Wendy Olson. We're going to see more from Wendy Olson in a minute when we switch topics. Partner at law firm, attorney of record for the Media Coalition, personal knowledge of the facts, and then just Exhibit A as a true copy, Exhibit B as a true copy of the non-dissemination orders. Fine. That's just establishing, hey, Your Honor, these are things on the record that you can take into account. Fine. Let's go take a look at the other non-dissemination order from who is this from? Rebecca Boone. Who's Rebecca Boone? Well, let's go find out. I don't know. This is the next the next in order declaration. Exactly. I can show you the world. Exactly. Sim Playkoya? P-L-Y Koya? Did he sign a confession? Yes, he signed the factual basis. And that's what we went through, the one that was read in court, the signed factual basis of these are the crimes, these are the elements. I'm admitting that I did these things. Yes. But to be clear, every time you see signed confession, that is what it is. There is nothing beyond that. So we have put it up very clearly. So that is what it is. Lyndon has made it more succinct. Did you crime? I did in fact crime. Declaration of Rebecca Boone in support of motion to be heard as interested parties and to vacate non-dissemination order. I am a supervisory correspondent for Idaho for the Associated Press. And the AP, when I broke down the pictures in the podcast this week of Bryan Kohberger in court in past days or in past hearings in past years, and then in court this last time, it was the AP who had a photojournalist or a photographer in court and had asked to have a photographer in court. And the court said yes. And then they provided a link so that people could access those photos because the AP can't claim exclusive rights in them because it's from court. Court gets around a lot of the copyright issues that can be so difficult. We'll have to talk about copyright more in days to come, but court gets around a lot of those issues, which is why doing what I do is easier than what some others do on the platform. And so I appreciate that the AP had a photographer there. Great. As such, I have personal knowledge of the facts and statements contained in the declaration. I have 26 years of journalism industry experience. Much of that time has been spent covering the judicial branch and criminal justice issues. I know I'm going to start a movement at some point to just stop calling it true crime and start calling it like, I don't know, courts and cases, like something else. But I digress. I have reported on the November 13th, 2022 murders of 4 University of Idaho students and subsequent criminal investigations and arrest and prosecution of Bryan Kohberger. And guilty plea. You can call them murders. I graduated from the University of Idaho with a bachelor's degree in journalism in 1999. Great. Covered courts, great. Background history, great. In 2013, I was promoted to my current position as supervisory correspondent. That must be exhausting. From 2013 to 2025 as the supervisory correspondent with the AP. Must be a lot. I have extensive experience covering criminal and civil litigation in state and federal courts. Can we get more coverage of the TikTok case? That'd be great. Thanks. I was an Idaho Press Club board member from 2014 until 2023 when I stepped down due to time constraints. Longtime advisory board member of the University of Idaho School of Journalism and Mass Media. Became a Loyola Law School Journalism Law School Fellow in 2012. I didn't know Loyola Law School had a journalism component. That's interesting. I also regularly serve as a panelist for training programs offered to teachers and journalists through a partnership between University of Idaho College of Law and the Idaho Supreme Court. Okay, background, training, experience. High-profile criminal cases present unique challenges and unique opportunities. The court has taken extensive and careful measures to maintain Mr. Kohberger's right to fair trial. Now that Kohberger has reached a plea deal with the state and has pled guilty, those fair trial concerns have resolved. That's a legal conclusion, but I don't disagree. The court should lift the non-dissemination order. Why is this an affidavit? Can you say how you're being restrained? Like, where's the tea on how this impacts you? Greyhound with Thumb said Loyola Chicago, Loyola New Orleans, and here I was thinking Loyola Los Angeles. I think Loyola School of Law is Loyola Los Angeles. Does Loyola Chicago also have a school of law? They may well. So, let's continue. I'm saving some of your questions. Big Ziggy, I'm saving that question for when we're done with this. We understand the court must balance the Sixth Amendment rights of the accused with the First Amendment interest of the media, which serves as a proxy for the public. We do not seek extraordinary access now. No, now, period. Well, right, because it's done. Rather, it is our hope that the court will simply reweigh the balance of the Sixth Amendment and First Amendment rights now that the plea has been entered. I think it should just be removed. I agree. One of the most basic rules for fair reporting is to seek comment from the subjects of a news story. Okay, you're just reiterating. I understand and appreciate that Wendy Olson is very careful in her writing, because Wendy Olson is like, I'm not the one speaking about the interests of the media. I'm the lawyer. So my argument is coming from this affidavit from someone in the media. I appreciate it. It is mindful legal writing, but this is why it just reiterates. It just reiterates what's in the motion. Offering subjects of news coverage the opportunity to comment or to respond to criticism or allegations of wrongdoing is a core part of most journalism codes of ethics, including the code of ethics used by the Society of Professional Journalists, and then they link that. Seeking comment and insights from people closest to an event or news story allows us to provide context, convey diversity of opinions, give a voice to the voiceless, and hold the powerful to account. Non-dissemination orders strip journalists of a crucial tool of informing the public. They are also a disservice to those bound by the orders, preventing them from asking journalists for corrections or clarifications in their coverage. I mean, the coverage shouldn't need clarification, because the coverage at this point, the coverage is supposed to be limited to what's in court. So there shouldn't need to be a correction. If it's in the court record says this. Lisa said Loyola Marymount University is in New York. There's a Loyola Marymount University in Los Angeles as well. I don't think they're connected, but there is. And that Loyola Marymount in Playa Vista, LA has a corresponding law school, because I know a lot of people that went there, but there's numerous. But yes, it's a fair clarification. It's like when somebody says USC, it's like, okay, but which one? And depending on where you live in the country, USC, you first think of, well, which coast do you first think of? Carolina or Los Angeles? But let's continue. Right. Some of you are like, South Carolina. Right. We can get into the whole conversation of which UT is the proper UT, but then we're going to start fights in the chat. And I like it when y'all like each other. Like which UT is the real UT? Continuing on. This declaration says the non-dissemination order in this case has not limited public interest or media coverage. Instead, it has only served to increase speculation and confusion. Well, there shouldn't be more confusion. The court documents say what the court documents say. If you just stick to the court documents say what the court documents say. All right? U of T, Canada has entered the chat. Fair. I declare under penalty of perjury under the laws of the state of Idaho. So the media is like, hey, Your Honor, can we get some of those interviews? Let's see if anything else has been added today. I don't see anything new on the docket. I don't see the court saying he's going to allow them to intervene or not allow them to intervene or setting a date, but I will keep an eye on it. For where we're at with Idaho, let's just try to summarize it. The court has put on the docket Bryan Kohberger's signed factual basis, which shows him saying, I am pleading guilty and admitting to the burglary and the 4 murders signed by him on July 1st. We have seen the plea agreement now put on the docket, signed by Bryan Kohberger and his attorney on June 30th, signed by the prosecution after that, because it went to the defense first and then to the prosecution and then to the court. We know that his sentencing is going to be a fixed life sentence. I've seen some confusion about the fixed life sentence, but from all of the law that I have gathered and everything I have looked at, fixed life means life. No opportunity for parole, no opportunity to ask for parole, and he waived his right to ask for reconsideration. He waived his right to ask for someone to consider this sentence differently down the road. So the way I read Bryan Kohberger's sentence is life, fixed, period, life. no parole, and no life without the opportunity for parole, because that's not what they're calling it. They call it life fixed, but life, no parole, life, period. Life, then life, then life, then life, then 10 for the burglary. That's how I read his sentence. No opportunity for parole, no opportunity for release, no opportunity to ask for reconsideration, no opportunity to say, well, the law has changed and now I should be reconsidered because the law has changed and now something's different. Done. So it was summarized in the chat. Theora H. White. Are you alive? You are in prison. So that is how I read it. I know there is some confusion on that, but it says very clearly in the plea deal, fixed life sentence, which means the sentence is fixed at life. And there is nothing he can do. He is waiving all of his rights to contest that. And that's what he has agreed to. So I know there's confusion, but I think it's just because different jurisdictions express that differently. There was confusion for me in the Sarah Boone case because it took me a minute to be like, wait a second. She didn't take that plea deal knowing that in Florida, if she's sentenced to life, it's just life, period. On a second? Like, ma'am, you're in Florida. Like your lawyers would have told you, look, if you go to trial on this and you lose, the judge can sentence you to life. And that is life, period. Life, dot. Nothing else. No parole at all. She had an opportunity for like a 15-year sentence. Florida's like, if it's life, it's life. We're not mathing. We're not mathing. We're not doing a 15 to life. We're not doing a 20 to life. We're not doing a 25 to life. There's no indeterminate sentence here. There's no, you can ask for parole after however many years. Life. And that's what I'm seeing here too. Life. Pink Rain said, wait, there's more than one UT? Yeah, the original SEC one. Until the other UT wanted to be in the SEC too and was like, hey, you got any more of that TV time? We'd love to talk about it. So we have seen Bryan Kohberger's signed factual basis, his admission or confession that he did all of these crimes. We have seen the plea deal. We have seen the fixed life sentence. And then we have seen that the media is like, okay, well, Bryan Kohberger no longer has a right to a fair trial because there's no trial. He expressly said that he understood and waived those rights when he pled. He was asked about his right to fair trial, his right to confront and cross-examine witnesses. He said he understood and he waived and gave up those rights. So now that Bryan Kohberger has waived and given up those rights, there is no jury pool to taint. There is no concerns for his right to a fair trial. So the media is saying we should now be able to ask whomever we want to ask for an interview to give comment. We should be able to be free from the non-dissemination order. And the prosecution saying, well, Your Honor, that would be annoying, is not sufficient. I'm going to pull up that hearing. This is going to be awkward for a second because I didn't plan on pulling it up, so I didn't look at the timestamp. But I really want to see what Bryan Kohberger. Miguelina, can you link me to the hearing we have in the in Law & Order TV? Because I want to grab that one. I really want to see if it was the court that gave that suggestion or if it was the prosecution that gave that suggestion. It was one of them, but the court said I can take this off. Can't I get rid of the non-dissemination? And the prosecutor's like, no, please don't. So it was the prosecution that objected then. So I'm going to pull that up. I want to see what the court said. I want to see what the prosecutor said. And then we will move on to, if you're not familiar with the TikTok case, hold on, I'm going to put up a poll real quick. We will move on. All right. see. Because some of you have joined us. Welcome. I just want to make sure I keep you appropriately in the loop. So I always want to ask, as we move into new cases beyond the Karen Reed case, like, are you familiar with this case, so that I can make sure you're all looped in? The chat has been so, law nerds, you're so lovely to each other. I love seeing how much the chat is like, oh wait, this is an inside joke from this, and make sure that the new law nerds feel at home and can find things. Thank you, Megalina, that's perfect. Are you familiar with the TikTok defamation case? Sometimes called TikTok psychic. It's so nice to see how our community grows of people who are just like, I love being here. So this is just going to be a yes, no poll. And I'm going to put this up right now. All right, let's go take a look at what the court said. That's loud. All right. This is going to take me a second to zoom. Wait, where did it go? What did I do? I messed it up. There we go. Emily, was that you? It's yes. Just all. I'm going to pull this up real quick and get us to the point where the court was asking about the non-dissemination order at the end here, because it was after the prosecution's not factual basis. It was after the prosecution's proffer, and it was after the plea that the court was just wrapping up on housekeeping. I think we're about the right place, but it might take me a minute. Streaming's dynamic.
As to count 4.
Nope, that's still the reading of everything.
Who share unique perspectives on
This is on the sentencing date.
that. We're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered
Okay,
that.
we had set aside dates. We're going to zoom past that just a little bit. And they are picking dates. After they pick dates, I think is when the court got to it, from best of my memory.
Any reason why I should not rescind the non-dissemination order at this time?
Emily, you found exactly where you want to be, and now you paused it. I did. That was faster than I thought it would be. Go us. Any reason why I should not revoke the non-dissemination order?
Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Your schedule is not a legal reason to keep this into play, because you have the option to say, we're not going to give any statement until after the sentencing. We would like the public to hear from those who want to speak at sentencing first. You have the ability to release that statement. And some would probably hold it against the prosecution, I'm sure, but I think some would understand we don't want to talk about this case until you've heard from those who want to speak at sentencing. I think that's fair. But it's not just about you.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least.
So the court did bring up the media requests. Thompson brought up timing. The court brought up the email.
My preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant.
And then the court moves on. The court's the one that brought up the, deluge of inquiries. Bill Thompson said, we want to have time to give a full full statement, which we can't do preparing for sentencing. Okay. I don't think that's legal justification. And that's really what the media is highlighting in this, is that just saying we need more time is not legal justification to keep a restrictive non-dissemination or gag order in place. And the court said for now, so the court did seem amenable to changing their mind, and the media coalition has stepped up and be like, yes, you need to change your mind. We have the right to reach out to who we want to reach out to. We'll see what the court does. I'm going to keep you posted. If things happen with this between now and sentencing, I will update you on the app, on the podcast, because I'm curious to see what will happen. I also kind of want the heads up if we're going to see a deluge of more information. We also know there are, based on the defense's motions, there are books set to be released. There are docuseries that are releasing, have been released, and will be released. So there is a lot of information that's going to come out about this case. But the non-dissemination order being in place at this point doesn't seem legally justified. This court is particular about the law, which I appreciate. Judge Hippler doesn't just do things to do things. And so this request might be well taken and it might get rescinded. And I will keep you posted on that. I'm actually surprised seeing that got filed July 2nd. We're on July 10th. I'm surprised there's not more on the docket about this in that period of time, truly. So we will see where this goes, or the court's going to be like, the court's bogged down with other cases. Oops, we didn't get to it until the 23rd, and then it's completely moot and withdrawn on that date. I think the media is trying to get ahead of that, as the interest in this case will continue to crest until that sentencing date. That said, our interest needs to continue to shift to the TikTok case, which 65% of you are familiar with, 35% of you are not. I'm going to answer a few questions that were specific to Kohberger before we move on to TikTok. Big Ziggy, I said I was going to hold on to this until we got to questions, but before we move on, sorry if I missed it. I was detained until now. Well, I'm glad you are free. I don't know Matt Murphy personally. Saying LWOP is not a true LWOP, but that Bryan Kohberger will be eventually eligible for parole. I would want to see the code section on that. That is not how I read the law. I do not think that is true. Everything I have seen, this is a life period, but if somebody has a code section or a site beyond vibes, I'm happy to take a look at it. But everything I've seen, fixed life is life period. I've seen nothing that indicates that Bryan Kohberger could ever possibly get out. I have seen no one from the families that are frustrated by this say, and he could possibly get out. None of them have said that. I think if that were true, we would hear particularly from Mr. Gonzalez that this is a complete miscarriage of justice. And if there were the possibility for him to be paroled, I would have much stronger feelings about it. But when we're looking at no appeals, life period, I get the balance. If it was the opportunity for parole, I would have much different feelings. And I don't see anything that indicates there's ever an opportunity for Bryan Kohberger to get out. The only way he's getting out of this sentence is if he dies. That's what it is. And how long that takes, well, that is between him and his creator. Brelina said, Emily, who decides what prison Kohberger will be sent to or rehomed? How the bureaus of prisons in different states work are a mystery to me, but that will be up to the prison system and their ability to keep him safe, their level of overcrowding. He can be sent, depending on which states Idaho contracts with. If they contract with other states, he could be in Idaho, he could be in other states. He would be in state prison. He would not go to a federal prison. So within the state system, especially in overcrowded states, California being the one I am most familiar with, you will see people held in prisons within California, but also across the US, just because those prisons have space. How California pays Georgia to house prisoners, I have no idea how it works. They all sort that out, but it is determined by the Bureau of Prisons or whatever that determining body for prisons is called in Idaho. So the prison system decides that on its own. Let's see. Carolina, are you going to cover the KR civil case motions, et cetera? We did that yesterday on the Corey Richins case. If we are talking about the Katie Richens cases. We covered those yesterday too. If you were talking about the Karen Reed cases, we will get back to the Karen Reed civil case. I covered it at the beginning when it was filed. We will get back to that. We have a minute. I wanted to cover some of this other stuff that has been pending first. Other cases that were pending first, but we will get back to it. M. Royal said, is the fact that there are so many typos legally fought by the defense? No, the defense signed it all. There are words left out. It was also read into the record. So at the end of the day, what was read into the record is going to be determinative. And it was read into the record as well. Natalie, this is a great point. Natalie said, I don't see how there isn't coercion when the death penalty is being taken off the table. That's not the type of coercion the court is talking about. The court is talking about, has your family been kidnapped and threatened? Have your parents been paid? Have you been threatened? They are talking about not that you are receiving a benefit from your plea, but that there is something beyond this. Like if you don't take this plea, you are going to be harmed. A loved one will be harmed. That type of threat or coercion, or even, hey, if you do this, then this. But that's not within the plea deal. The plea deal is open and transparent that if you plead, then the death penalty is off the table. That is part of your plea deal. Things that would be off the record and coercive and threats are a different one. Let's see. So accepting a plea deal, which is basically agreeing to a negotiation between prosecution and defense, legally signifies guilt. In this case, yes, because of the plea. There are some cases, and you will see them called no contest pleas or Alford pleas, depending on the jurisdiction. There are some pleas where somebody pleads guilty to a criminal case and says, I am pleading guilty, but I am not admitting guilt. I'm not taking responsibility. Sometimes you'll see that in cases like involving vehicle collisions, if there's still an insurance component waiting, or there's still civil lawsuits waiting, that somebody will move forward the criminal case with a plea to do their community service or whatever it is in the case, but they're not accepting guilt in the case because then it can't be used against them in the civil case. So you will see that. But in this type of case, him accepting this plea deal, he signed that factual basis saying, I did this, I am guilty of this. So yes, that is him admitting and confessing that he did these things in this circumstance. Different guilty pleas are different, but in this case, that is how I read that. Let's see. Webfan said, Emily, can you have a handwriting expert guest give an analysis on the documents and signatures? No, because I don't know how he signed them, and I don't know if he was handcuffed or not, and that can impact things. So no, not with this one. And the speculation about Bryan Kohberger as a person or any diagnoses and what have you is not really what I'm focused on, especially when those things are discussed in context of his criminal case, because those become advocacy. And there are a lot of feelings, I have them myself, about using diagnoses as a scapegoat in a case. I understand why defense attorneys do it. I am not leaning into it because, well, for a lot of reasons, but zealous advocacy doesn't always comport with the way the inside of court and outside of court. So that's part of why I'm not getting into all of it. I also don't love how much I'm seeing the media lean into the name calling on Bryan Kohberger. He admitted to horrific and awful crimes. Horrific and awful crimes. We don't have sufficient answers for those crimes, but trying to diagnose him, trying to name call doesn't bring us answers. It doesn't bring us answers. He's confessed to horrible crimes. That makes him a convicted murderer. I'm not going to go beyond that. Tina KS, thank you for the 20 gifted memberships. Let's see. We are working on the app having milestones. We are working on the app having milestones. It is on our list. We are working on the app not crashing because there's so many law nerds first. Milestones are a huge part of on our list. Let's see. Carrie said I was a member longer, but my credit card changed. Carrie, I would reach out to Google support and see if they can help with that. I hope that they can, but I would reach out to Google support and see if they can help with that. Unfortunately, I don't have control over that. You know how I feel about having control. I would love to just wave a magic wand and fix it. But the mods can give you a link and tag you, if I didn't take that down too fast, on how to reach out to Google. They might be able to help that and go look at that in the back. Okay. Let's see. Those are our questions on Kohberger, and we will move into the TikTok psychic case. Let's give a background for those of us who are new to this case, because buckle up. There are some cases that challenge our ability to be creative in voicing our displeasure. This is one of those cases for me. And I will always tell you when I have feelings about this case. This case, from the moment it was filed, I'm like, the case, not the case itself. The fact that this plaintiff had to file this case is fuckery to me, and it pisses me off. People should not have to spend years in litigation to get someone to stop someone from accusing them of a murder that they didn't commit and that there's no evidence that they committed. It's frustrating to me, and I do not like it. And it is fuckery. And it is not even speculative. It was not even like, oh, it could be this, it could be this, it could be that. No, it's bullshit. So I have very strong feelings about this one. And, well, those are my feelings. So the perspective I'm coming from at this is this shouldn't be happening, and I hate that this professor has to pursue this litigation. But we're still in Idaho, but we've enjoyed flying there today. So do we just do airlines one more time? No, we're going to swoop. I'm going to be restrained. Swoop. The Idaho University defamation case started shortly after the prosecution of Bryan Kohberger. There was a University of Idaho professor, and I generally refer to the parties in this case as the professor and the TikToker, mostly because I don't want to lean into the TikToker's name and identity to bring any more attention to that, because I think that when people are desperately seeking attention online, that much like a fire, you need to snuff out the oxygen on that. I don't use the professor's name, not out of disrespect, but because I don't think, the transcripts of these videos all live. I don't want to continue to populating this professor's last name connected to this case in this way. So that's part of the reason I refer to the professor and the TikToker the way that I do. The TikToker did a ton of TikToks. At one point, the attorneys called it a clout circus. A ton of TikToks accusing a professor from the University of Idaho of hiring a hitman to take out one of the victims, and to take out that victim because the victim was a student of the professor and they were having an intimate relationship, which also goes into the defamation because it is inappropriate for the professor to have a relationship with their student based on their position of being a professor. It goes against their employment contracts. It goes against their employment handbooks. So when I talk about it being an inappropriate relationship, I am talking about it in the context of professor-student, that relationship. The professor never taught any of the students that were victims in this case. The professor had no connection to any of the students that were victims in this case. And it seems from all of the filings here that the TikToker said, no, I am clairvoyant and claircognizant. And I went through the university's website and was guided to the history department and was guided to this professor, and then did readings with tarot cards on this professor. And then it came to light that this professor is the one who hired the murderer. And then this entire story about why and how the professor, they say, hired individuals to carry out these murders. There were hundreds of TikToks, and then there were a flood, a deluge, if you will, of news stories about these accusations. The professor sent multiple cease and desists to the TikToker. The TikToker did what a lot of content creators do with cease and desists, which is turn it into content. There are some cease and desists that are absolutely bullshit. You send a cease and desist to somebody that's like, please stop talking about my legal case. Well, it's in court. No. But a cease and desist of, hey, I didn't commit a murder. I didn't hire anyone to commit a murder. Stop saying that I did. That's not reality, is one of those times where maybe, just maybe, the cease and desist should have been heeded. We would not have gone further. So that was not heeded. The cease and desists became content. The TikToker quadrupled down. They have since been taken off of TikTok. And I think almost every other platform except maybe YouTube, but maybe YouTube. And continued to double down. The TikToker then chose to represent herself in this federal defamation lawsuit and has continued to double down, quadruple down, double down as much as humanly possible. The TikToker made a request, and I covered this a little while back, I think in the podcast, made a request to Judge Hippler, to Judge H, in the murder case for documents. And it was immediately no. The TikToker requested from Judge H sealed documents to try to prove her case. However, the federal court in the defamation case has already found her liable for defamation on a motion for summary judgment. Procedurally, the defamation case is waiting to go to trial on damages only. And they have not been able to set a trial date because every time the court does anything, the TikToker goes, objection. And a lot of those objections are not valid objections, but there is still process to them. I have attended a number of the hearings in this case. They've been remote. It is difficult to listen sometimes to the circular reasoning of the TikToker, because the circular reasoning is she can't prove it's not true. She, professor, can't prove she didn't murder anybody, so I can say whatever I want because she can't prove she didn't do it. That's not how that works. You have to prove that you have some type of evidence that indicates that your claim that she is a murderer, and the TikToker calls the professor even to the court, a murderer, and has said, well, Your Honor, I know we've done some discovery and she says she's not a murderer, but I'm not going to believe that because she's a murderer. Like, la, 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 la. And the court's like, okay, boo-boo. The court would never say that. That's not how that works. You need to have like evidence to support your position. And she said, I do have evidence. I think it. So that's not evidence. And the court has gone a very long and patient way to say that's not evidence. You having a thought or reading it in tarot cards is not evidence. And so then the TikToker said, you are impeding my right to free religion. This is a religious belief. And the court's like, no, you can practice whatever you like. You can believe whatever you like. But what you can't do is go online and accuse someone of crimes and impropriety in their business based on that. That's not evidence. You can read tarot cards all you want. Go ahead. But tarot cards can't be cross-examined. And I have no shade for tarot cards. But you can't use that as a foundation of evidence to accuse someone of crimes. So the court has been exceedingly more patient. This case will remain a highlight of, Emily, you should be a judge, and why the answer to that is fucking no. The judge has been incredibly patient. And each order from the judge goes through basic concepts of law that you wouldn't have to explain, but for the fact that the TikToker is representing herself. Because you could sanction a lawyer at this point. Courts are more hesitant to sanction pro per and pro se defendants, though I think we might get there in this time. The history of this case is long. The TikToker has included things in their filings, such as the FBI saying that they had used psychics or mediums to help them know where to look for things. And that's why this should be a defense to defamation, which those two things don't follow. And why the court's interpretation of the rules of evidence infringe on her rights. So that's where we're at. Procedurally, the court has found defamation. The court has found the TikToker liable for defamation. The TikToker has, since that finding, tried every single avenue to get a different judge, to get this reconsidered to, and all of it has been shut down. They are trying to pick a date for trial on the damages. The court asked the parties to meet and confer about having court mediation to determine damages. The court's like, why don't we sit down together? And if we sit down together, maybe we can come up with an amount of damages. Because I think the only thing that's going to work here is an order from the court to keep the professor's name out of your mouth. Even then, I don't know if that will work. But the frustration that I find with this is there are some avenues where the court is ill-equipped to fix the thing. Because even if there are monetary damages here, it starts another lawsuit, truly, to collect those damages. And I don't know what the TikToker's source of income is. I'm not going to go investigate into that. But if they were making most of their income from platforms that they've now been taken off of, I would wonder if the TikToker would willfully keep income low so that it can't be garnered in any way in this lawsuit. So, with all of that, we are going to go through the updates for this case that we haven't covered yet. There is a playlist on this case if you are interested in all of the wildness. There is lots of wildness. I'm trying to remember what I covered last because it's been a minute. The TikToker had asked for reconsideration of the summary judgment. We covered that. We covered, I think, last the order on that. I'm going to summarize that one real quick. This was from May 30th, and then we'll move forward from the things after May 30th because I'm not sure if we covered this one or not. But let's cover this. Even if it's a duplicate, it will catch us back up to where we were because the summary judgment motion is after discovery is closed. And so the court considered all of the evidence, oral argument, and the rest of it on summary judgment. And the court said, yes, there is no way that this can go forward on the question of liability. There is no defense to this. This is defamatory. This is defamation per se. And you are liable for defamation. So the liability's been determined. So now, after that, the TikToker was like, well, nuh-uh, I want a new judge. And then another judge had to consider it. And the other judge went, no, you don't just get a new judge because you don't like the ruling. That's not how any of this works. And so then it got kicked back to the judge who's been handling it. And then she said, you need to reconsider this. And the judge was like, no. So we're now here with you should reconsider your motion for summary judgment ruling. And the court's like, no, I'm not reconsidering that. I said what I said. So we're at the court in its patience telling the TikToker defendant that, well, no, So this is the memorandum decision and order regarding the defendant's Rule 60B2 motion for reconsideration of partial summary judgment. It's partial because the court didn't find damages. That's the next part. That part's going to go to trial. It was on liability only. And we've seen cases go forward on damages only. It's just been a while. Okay. Let's continue. Background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Remember, this is from May. All the filings we're going to see are from before Bryan Kohberger's plea. All of them. Plaintiff is a professor at the University of Idaho. She alleges that despite never meeting any of the students or being involved with their murders in any way, defendant TikToker posted numerous TikTok videos and later YouTube videos falsely claiming that plaintiff, 1, had an extramarital same-sex romantic affair with one of the victims, 2, ordered the 4 murders to prevent the affair from coming to light. Plaintiff sent cease and desist letters to defendant in the following days and weeks. When defendant did not stop, plaintiff initiated this action. Plaintiff asserts 2 defamation claims against defendant, 1 premised on the false statements regarding the involvement with the murders, 1 premised on the false statements regarding plaintiff's romantic relationship with a student. Again, it can be defamation per se in most states to say that somebody is acting improperly in their profession in this way. We went through all of those motions. On June 6, 2024, yeah, I said 2024, a year ago. June 6th, hold on, let me get the filing date of this for all of our new law nerds. This case was filed December 21st, 2022. They have been litigating this since December 21st, 2022. The liability finding was June 6th, 2024. It is July 10th, 2025, as I'm recording this. On June 6, 2024, the court granted plaintiff's motion for partial summary judgment. On the issue of liability for plaintiff's 2 defamation claims against defendant, the court concluded plaintiff sufficiently demonstrated the absence of any genuine issue of material fact. That's the standard for summary judgment, relating to the falsity of defendant's statements about her. There's no question of fact that these are false. The jury can't decide a fact if there's no question of fact. After citing evidence stating this is powerful evidence at the summary judgment stage, it not only substantiates plaintiff's argument and defendant's statements about her are false, it also highlights the complete lack of any corroborating support for defendant's statements. That's what the court ruled. Complete lack of evidentiary support. And then the TikToker was like, I told the FBI tip line. That's facts. Under Rule 56, this shifted the burden. Again, the court's explaining procedurally where we're at. Under Rule 56, this shifted the burden to defendant to dispute that claim, because there's 2 parts to that summary judgment, to dispute that claim by setting forth facts showing that there is a genuine issue for trial relating to whether her statements about plaintiff are true. In relying only on her spiritual investigation into the murders, however, the court concluded that defendant did not satisfy her burden. Weird. But Your Honor, my guides told me. Your guides should have told you not to say that shit out loud. I don't think they would have led you astray that way unless they really don't like you. That's just me being mean at this point. Emily, rein it in. Though there was one point on one of these hearings where the court asked TikToker a question and she said, literally and legitimately, I didn't see that question coming. And I have never been so glad that the phone was muted because I almost fell out of my fucking chair. I didn't see that question coming. Oh, ma'am. Weird. There is no stopping while you're ahead in this because the TikToker is not processing through decision-making in a way that is self-sustaining. This is not going to go well at all. But also, how do you fight with someone who's just like, I said what I said. I think what I think, and I can say whatever I want about you. I don't care if they say it's defamation. They're wrong. Everyone's wrong but me. How do you fight with everyone's wrong but me? Especially when they're not every month sitting there raking up the lawyer bills that they're paying. How do you fight with that? Like, fine, I'll keep representing myself. I don't give a shit. What do you do? Other than go through the court process, have the rulings, and go to the media companies and be like, can you take those headlines down? I won. I don't know. So the court said, in relying only on her spiritual investigation into the murders, remember the spiritual witness? The court concluded that defendant did not satisfy her burden. As a result, defendant's psychic intuition without more, the court said this in their ruling. As a result, defendant's psychic intuition without more cannot establish a genuine dispute of material facts to oppose plaintiff's summary judgment efforts. The court therefore concluded that the totality of the evidence reveals that there is no genuine dispute as to any material fact that defendant defamed plaintiff. Also on June 6th, the court granted plaintiff's motion for leave to amend the complaint to add punitive damages. Because in Idaho, the court has to say yes. And the court is like, yeah, if there's a case for punitive damages, it's this case. Go for it. Get your punitive damages. Whether you can collect on them, different story, but get your punitive damages. In permitting a claim for punitive damages, the court concluded that plaintiff established a reasonable likelihood of proving by clear and convincing evidence that defendant's conduct in accusing plaintiff of an affair with a student before ordering that student and 3 other students' murders was oppressive, fraudulent, malicious, and or outrageous. The extent of plaintiff's damages, if any, remains an issue for trial because they can order punitive damages. A jury can be like, you know what? This doesn't fly. Like, it's up for the jury, and through this, you can only do money judgments. We do not support, as a jury, this behavior. Stop it. This is beyond the bounds of decency. It is malicious and outrageous. Knock it off. So here's money for this side. Hopefully that money punishes you enough that you will stop it and learn your lesson. The problem is, if a defendant is underfunded to meet that, what's it matter? They're like, I don't care. I'm not paying it. Come get it. Come get it. And that is a very real problem in this case. Defendant then moved for, quote, reconsideration, alteration, or amendment of the court's June 6, 2024 order. The defendant specifically argued that the MDO order was, one, oh, that's right. This defendant has told the court a couple times, you're just wrong. The audacity. How long has it been since the federal judge has been told in court that they're just wrong? Because it happens in their personal life, I'm sure, plenty, especially if they have kids. But in court, you're just wrong, Your Honor. You're just wrong. You can't, Carl Baker said, easy, contempt of court, jail her. You can't find people in contempt for failure to pay. Defendant argued that the order on the motion to dismiss was, 1, based upon a manifest error of law and fact, 2, should be amended to prevent manifest injustice. This is not how manifesting works. You can't just put manifest in front of words and manifest the result. I'm pretty sure that's not how that works. That's not how that goes. Should be amended to prevent manifest injustice and an impediment to justice due to lack of judicial impartiality. And 3, erroneously allows for excessive damages. Oh no, ma'am, you allowed for the excessive damages by failing to ascertain the situation properly. These reasons, according to defendant, warranted the wholesale dismissal of the case under Rule 12H3. The court disagreed and denied the defendant's motion in response to defendant's particular arguments, concluding that the MDO did not violate the First Amendment. The court has subject matter jurisdiction, because she brought up subject matter jurisdiction. No, not a soft sit, but I'm sure we'll see some more of those arguments. This doesn't violate your First Amendment rights. You can't defame people. The court does have subject matter jurisdiction. It properly resolved the defamation claims. The court has not violated defendants' rights to a fair tribunal, and Idaho law permits a claim for punitive damages, and defendants' defamatory statements are not privileged. Chat, do you want to let our new law nerds know what privilege she claimed? Just put it in the chat. I'll come back to it. I'm letting chat answer. Yep. TikTok privilege. She claimed TikTok privilege. But I said it on TikTok. It's TikTok privilege. Yep. I know. For all of you saying, what the fuck is that? It's not a real thing. No, it's not a real thing. TikTok privilege is not a real thing. The court sidestepped the fact that she was arguing First Amendment, not just based under freedom of speech, but also based under freedom of religion. And that has come up quite a lot in this, that the court is infringing her freedom of religion. Right. You can practice your religion, but you can't commit crimes and say that's part of your religion. So that's, well, or civil torts. Now, via the pending motion, defendant again moves to have the court reconsider its June 6th MDO. A lawyer would never do this, because now we're bringing excessive motions that don't have legal basis. This time, pursuant to Rule 60B. I can just picture the, hey, ChatGPT, what other rules of federal civil procedure allow me to ask the court for reconsideration? Defendant claims that newly discovered evidence, and we went through these motions, that newly discovered evidence in the form of filings in a related state court criminal proceeding provide factual support that substantiates the TikTok videos that defendant posted regarding the murder of the 4 University of Idaho students. Those are filings from the criminal case involving the text messages between the roommates. And the court was just, no. Defendant maintains that she cannot be found liable for defamation because this newly discovered evidence proves that she was telling the truth in these TikTok videos or otherwise highlights outstanding issues of material fact that preclude summary judgment. Plaintiff again opposes defendant's latest motion in its entirety. The arguments are considered below legal standard. Under Rule 60B, the court may relieve a party from final judgment, order, or proceeding for the following reasons. 1, mistake, inadvertence, surprise, or excusable neglect. 2, newly discovered evidence that, with reasonable diligence, could not have been discovered previously. Asterisk that. 3, fraud, misrepresentation, or misconduct by the opposing party. If the opposing party's hiding evidence, not answering the interrogatories, not fully complying with discovery, or provided false discovery, that is a reason that a particular ruling or order can be overturned. The judgment is void. The judgment has been satisfied, released, or discharged. Any other reason that justifies relief. Rule 60B is an extraordinary remedy and is granted only in exceptional circumstances. The moving party bears, and this is the TikToker, bears the burden of proving the existence of a justification. Here, defendant relies on Rule 60B2 when she claims the newly discovered evidence exists that, quote, corroborates the truth and accuracy of her statements about plaintiff's involvement in the November 2022 murders. Spoiler, it doesn't. Relief from an order on the basis of newly discovered evidence is warranted if 1, the moving party can show the evidence relied on in fact constitutes newly discovered evidence within the meaning of Rule 60B. 2, the moving party exercised due diligence to discover this evidence. And 3, newly discovered evidence must be of such magnitude that production of it earlier would have been likely to change the disposition in the case. That's what the court's considering. See, there's rules. That's what the court's considering. Discussion. Defendant argues that newly discovered evidence revealed in the parallel criminal proceeding in state court tracks statements made in her earlier TikTok videos about various circumstances surrounding the murders. For example, defendant claims that newly discovered evidence, and again, it's not newly discovered, it came up in court filings in the criminal case, it's not new. For example, defendant claims newly discovered evidence confirms her statements about, 1, how the surviving roommates were afraid the night of the murders. Ma'am, you didn't have any of this at the time you made the statements. You have to prove that at the time you made the TikTok videos that you had support for these facts, and you didn't. But she's saying, I said they were afraid. You said victims of crime were afraid? What a shocking and stunning revelation. Yes, people are afraid. That's not proving that the professor did any of this. She made this motion after the filings with regard to the roommates' text messages. How the surviving roommates were afraid the night of the murders. 2, a dog being in the house at the time of the murders. That was in the news incredibly early on. 3, a breakup involving one of the victims and her boyfriend. 4, the 4 victims being located in 2 different rooms. 5, the imminence of an arrest. For all of you saying, hey, what's that have to do with the statements made in this case? It doesn't. You're correct. You're reading that correctly. From this, defendant contends that the perceived synergy between her psychic intuition and that synergy was a word the defendant used, between her psychic intuition and the newly discovered evidence not only validates her separate statements about plaintiff's role in the murders in relationship with one of the victims, but it also highlights how her theories about the murders have never been proven false. And therefore, her absolute defense of truth against plaintiff's defamation claims remains plausible. Plaintiff counters that defendant's arguments are procedurally improper because the June 6th order is not a final judgment. Plaintiff additionally argues that the evidence defendant cites is not admissible and regardless does not affect the court's analysis. Plaintiff lastly questions defendant's diligence, arguing that she was aware of most of the evidence she now relies on in her motion, i.e. the evidence is not new at all. But did nothing to formally obtain it during discovery or otherwise make an effort to incorporate it into her summary judgment briefing. Footnote 1. The court agrees with plaintiff. Footnote 1. Plaintiff's position in this respect may explain defendant's recent notice to the court of requested documents, docket 95. The defendant notified the court of her public records request following the state's court's denial of her motion for access to non-disclosed records in the criminal action. The defendant filed a motion in the murder and said, hey, give me all of the sealed documents. And the court said, I'm paraphrasing, who the fuck are you? No, that's not, no. The court agrees with plaintiff. Even assuming defendant's reconsideration efforts were procedurally proper, I love the arguendo. I do appreciate the patience of this court. The court could say, this is procedurally improper, done. They don't. The court goes on and explains the reasoning because the court's like, even though this is procedurally improper, let me explain so we don't find ourselves here again. The court makes an incredibly thorough record. Even assuming the defendant's reconsideration efforts are procedurally proper and that the referenced evidence is both newly discovered and admissible. So arguing best case scenario for TikToker, considering all of that, even if all of this, defendant's motion suffers from a fatal flaw. The evidence does not change the disposition of the case. Absolutely nothing. I will accept this absolutely not. Absolutely nothing about this evidence suggests the defendant's statements about plaintiff are true. That certain of defendant's psychic insights may have randomly coincided with banal aspects of notorious and well-publicized murders is hardly surprising. But this happenstance alone does not legitimize defendant's perceived clairvoyance, nor can it bridge the gap between defendant's intuition and the truth. The court has gotten much, much, much more pointed in the strongly wording of the order. The court was gentler in their wording early on, and the court's like, it's enough. It's enough. You can't accuse someone of murder. Stop it. This is enough. This happenstance alone does not legitimize defendant's perceived clairvoyance, nor can it bridge the gap between defendant's intuition and the truth. Look, lots of people should trust their intuition. However, those are for action for you, the things you decide to do or not do. It is not the, or even if this defendant had called the tip lines and sent tip line emails and said, this is what I think, look into it, we wouldn't be here. If it was reporting to police, we would not likely be here. The fact that instead of reporting what she perceived or decided was the case here, she didn't report it to law enforcement. She reported it to TikTok. Why would she have done that? If she was worried about solving the case, why not go to the tip line? No, she went to TikTok. So, this is not how that works. This is not how this works. She did call the tip line. SoCo SLP, she did call the tip line, but it was much, much, much later in all of this, after the cease and desists. She didn't call the tip line until after the cease and desists. That's right. Knight 1007 said, because TikTok gives you immunity, Emily. Duh, you're right. My bad. This sparkling rutabaga, if anyone's talking about this person being a vexatious litigant, they're not. They're the defendant here. So that is not the circumstance. The professor is suing to try to get this to stop. Sinister Girls, good to see you, said, isn't the lawsuit moot? No. Because liability for defamation's already been found here. The defendant's already liable for defamation. The only outstanding question is damages. How much money do you owe to the professor for the shit that you said and posted? So the case is already liability-wise done. But she continues to try to keep this going any which way. Shauna said, does the plea deal help the case? Not really, because liability's already been found. And this defendant is not going to see the plea deal as negating her statement that the professor hired people to commit the murder. This plea deal is not going to change the TikToker's mind at all. Not at all. Or we will see arguments, and this is me trying to put myself in the mind of the TikToker, or we will see the TikToker say, well, Bryan's taking the fall to protect everybody. Those are the types of arguments we will see. I don't believe that or agree with that, but we're at the point with the TikToker that nothing is going to change their mind. Just period. They are too dug in. So there's no unwinding this. Ultimately, the cited evidence is wholly unrelated to plaintiff footnote 2. If anything, it underscores that there continues to be no evidence that plaintiff had an affair with a student or orchestrated the murders to keep that affair secret. Footnote 2. Oh boy. Defendant's attempt to associate plaintiff, professor, with evidence about a white Hyundai Elantra being involved in the murders also falls short. And the court is citing the motion at 9. Defendant stated on the video that plaintiff had access to a white Hyundai Elantra the night of the murders and that she drove to the scene of the homicides to ensure the execution of the murders. On January 12, 2024, plaintiff admitted to having access to a white Hyundai Elantra during the night of the quadruple murder of 4 students. The state's Exhibit A alleges evidence that a white Hyundai Elantra was seen near the area of the homicides several times. Defendant's reliance upon a request for admission from plaintiff to defendant to prove this point is not only misplaced, but fails to make the connection defendant seeks. Based upon the record before the court, plaintiff never admitted she had access to a white Hyundai Elantra. For those of you that are very familiar with law, you're on the same page with me. For those of you that are like, tell me what that means. The court is saying that the defendant took a request for admission, which are sent out in civil cases, admit that you have evidence of this, admit that you have evidence of this, admit these things, or admit that this is not true. Admit or deny. Plaintiff sent a request to the defendant saying, do you essentially have any evidence that plaintiff had access to a Hyundai Elantra, was driving a Hyundai Elantra, any of these things? And then defendant said, you're asking me a question about that. That means it's true. And then used it in the filing to say, oh, you said it's true because you asked me a question about it. That's not how that works. So the TikToker is taking a question to her and flipping it and saying, you admitted this. Anyone ever argue with someone in their personal life like this? It's exhausting. Run. Gray rock is the only option. Like, oh, you said that. That means you're admitting it. I was asking you a fucking question. What? This. Woo! Buddy. Lady Witch said, does that actually work in court? No, hence the sassy federal judge footnote. Continuing on. The court was like, let me just put an end to this. And I appreciate the court saying, you're filing this shit in court, trying to make fetch happen, and I'm going to disabuse you of that. It's not true. Ultimately, cited evidence is wholly unrelated to plaintiff. If anything, it underscores that there continues to be no evidence that the plaintiff had an affair with the student or orchestrated the murders. Defendant's insistence about how her theories surrounding the murders has never been proven false is likewise unavailing. She claims that evidence pertaining to 3 sets of DNA under MM's fingernails, the victim's defensive wounds, and blood at the crime scene from 2 unidentified males is not inconsistent. It's not inconsistent. You can't prove that it's different because anything's possible, right? The Lexus could just shoot off into space. Anything's possible. It's not how defamation works. It's not how defamation works. IR in the chat said this feels like the definition of bad faith 100%. 100%. She argues that what's in the motions in court, not evidence in court, in motions in court, in this criminal case, is not inconsistent with her underlying theory that plaintiff orchestrated the murders and framed Bryan Kohberger, the defendant in the state criminal action, by planting a knife sheath at the crime scene. Her theory has continued to grow. That was my interjection. The court did not say that in the ruling. For those of you listening in the background, did the court say that? No, that was me. But this misses the point. As the court already stated, judicial per my last email, This case is not about whether Mr. Kohberger committed the murders. So when we get to, does the plea in the Kohberger case really change this? No. She's already been found liable of defamation because TikToker can't substantiate her claims at the time that she made them. She has no evidence to say this is what I am basing my statement on. There is no objective evidence to support it. You can't just say shit. Though the court's consideration, or through the court's consideration of these issues, may have touched upon the matter of criminal concern in a parallel criminal proceeding in state court, the court never endeavored to apply the elements of murder and allege the plaintiff innocent and Kohberger guilty, because it's not the point. Do you have objective evidence to support what you're saying when you said it? This case is about whether defendant defamed plaintiff by repeatedly accusing plaintiff of an affair with a student before ordering that student and 3 other students' murders. On that linchpin point, Your Honor, this defendant's going to take issues with this sentence. She's not going to understand what you mean. On that fundamental point, the court concluded that there is no genuine dispute as to any material fact that defendant did so, regardless of whether Mr. Kohberger or anyone else committed the murders. This was written well in advance of the plea. This evidence that defendant cites in support of her motion does not change the conclusion because there continues to be no corroborating support for defendant's statements about plaintiffs. For these reasons, the motion is denied. Literally, the defendant's entire arguments are just... That's my opinion! Right. So, the court said, no, I am not reconsidering. You are liable for defamation. We need a trial date. And the court has asked repeatedly, do you want to do mediation to try to mediate the damages? Court mediation is likely, in my opinion, to result in a lower amount of damages. If this goes to trial, those punitive damages open up a world of the jury feeling the way you do. Because to determine damages, the jury's going to hear all of this and see some of those TikTok videos. A jury in Idaho who might be aware of the Kohberger case. A jury in Idaho is going to come in and be like, you said what on social media? You can't just wild out. The internet being the Wild West is reining in more and more and more. And I can imagine a jury sitting there going, this is not acceptable. This is beyond the bounds. Fuck you. Here's damages for the professor. Because I can't imagine a jury not feeling incredibly empathetic to the professor once they hear all of this. They don't even have to decide it was defamatory. The jury's going to get told, this is defamation. How much money is owed to the professor? And a jury can go, oh, all, fair, all. Don't do this. That's what punitive damages are for. Punitive damages are trying to rein in the boundaries of behavior. And that we often see this in personal injury, civil cases, and others. I don't disagree that it's appropriate here. This is not a case where 2 parties are perceiving a thing differently. This is a case of blatant, reckless, malicious defamation. And it's fair for a jury to say, no. All. If you go through court mediation, I think it would rein in a bit. Let's talk about that court mediation in a minute. We're going to get through some of this. We just went through the court's order. You're going to be shocked at what comes next. Get out your shocked Pikachu face. The TikToker has objections. The TikToker has objections to this order from the court. Objection, Your Honor. Hold on, where is it? Emily, you're having too much fun with your soundboard. No, I'm not having enough fun with my soundboard.
Not today, Judge.
So the court writes that order, and then TikToker says, yeah, about that, no. She is representing herself. TikToker is the defendant in this case. Professor is the plaintiff. Defendant's objections to magistrate's decision and order on May 30th, 2025. This civil case presents a conflict of weighing the fundamental constitutional right of the freedom of expression and the moral or legal duty of citizens to publicly report a crime that is a matter of public safety against alleged defamation of character. Ma'am, you didn't write a police report. You didn't make a tip to the police. You are not the police. You don't get to enforce that. And you didn't, you went to TikTok first. So, no, just no. This case also presents an issue of a conflict of interest between this civil case and the criminal case of the state of Idaho versus Bryan Kohberger. No, it doesn't. No, it doesn't. Where is my nope?
Nope.
No, it doesn't.
Nope.
Professor believes that the state is, no, TikToker, I'm sorry, she's referring to herself in the third person and not as defendant. Defendant believes that the state is prosecuting the wrong subject for the 4 counts of murder in the first degree for the murder of the 4 students. Moscow Police Department stated on December 27, 2022, that they did not believe TikToker's statement. Yeah, this blew up so big that Moscow PD put out a notice saying that this is not true. It gained enough attention on social media that the police department had to respond to this. That's how much traction this gained. Moscow police stated on December 27, 2022, that they did not believe Gouliard's statement that plaintiff professor ordered the murder of 4 University of Idaho students found dead on November 13th, 2022 in Moscow. A non-dissemination order was issued in the criminal case and evidence is being withheld from the public. They don't have anything to do with each other. However, in 2025, through pretrial motions in the criminal case, some evidence has been revealed, i.e. text message extractions from the surviving roommates and the grand jury transcript. The grand jury transcript is not public. Some conversation of it is. Nearly all the evidence that has been revealed to the public substantiates TikToker's account of the murder of the 4 students. No, it doesn't. That's my interjection. TikToker submitted a public records request for the evidence in the criminal case that she believes substantiates her claims that Professor is an accomplice in the murder of the 4 students. Ada County has not released those records to TikToker, nor have they complied with the Public Records Act request. That request that requires them to grant or deny the request within 3 days. The court denied it. We pulled it up. I covered it on the podcast. The court denied it. The evidence that potentially affirms TikToker's defense of truth is non-disclosed and being withheld from the public and TikToker by Ada County in the state of Idaho. This causes an issue of material fact in this civil defamation case. No, it doesn't. It also, that's not what these words mean. It also causes a due process issue for defendant because this U.S. District Court, under the tutelage of Chief Magistrate Judge Patricio, required defendant to provide evidence that Professor ordered the murder of the 4 students. That evidence is being withheld by Ada County. Ma'am, if you can't substantiate the things that you say, and those things are defamation or defamation per se, then it's defamatory because you had no evidence of it at the time that you said it. You have to have the evidence. It doesn't matter what's in the court file in the criminal case. You have to have that evidence. Objective evidence that can be entered in court. Because you don't have the evidence, you can't make the accusation. Also, I fully believe if Ann Taylor thought there was anything to any of this, that this avenue would have been pursued. However, the court ruled against any alternate perpetrator theory because there's no evidence of it. All of that before the defendant pled guilty and admitted that he did this. So, the facts are not here. Standard of review, according to the TikToker says that the court should reconsider their order and that the district judge may also consider sua sponte. Well, this isn't sua sponte. You're making the motion, but whatever. A district judge may also consider sua sponte any order by a magistrate judge found to be clearly erroneous or contrary to law. That's not the case here. Additionally, written objections and the subsequent review by a district judge may also be necessary for appeal. Legal standard for Rule 72, we're skipping objections to the magistrate's decision and order. Under Rule 56, to succeed on a motion for summary judgment, the movement must show there's no genuine dispute of material fact. We're just relitigating this ad nauseum. That the movement is entitled to a judgment as a matter of law. Second, an award of punitive damages requires a bad act and a bad state of mind. Citing Todd V. Sullivan Construction LLC. I need to start site checking these to see if any of them are coming from like ChatGPT hallucinations, because that's coming up more and more in cases, but I have not had time. The defendant must, 1, act in a manner that was an extreme deviation from the reasonable standards of conduct with an understanding of or disregard for the likely consequences. You were notified of the consequences in the cease and desist. 2, act with an extremely harmful state of mind, described variously as with malice, oppression, fraud, or outrageousness. We've got more outrageousness at this point than Gem and the Holograms, ma'am. What if not this? Relief from an order on the basis of newly discovered evidence is warranted if the moving party can show the evidence relied on in fact constitutes newly discovered evidence. The court already said no. This is getting into like Carrie Morrissey levels of I am going to keep relitigating the point. And the court's like, I said no this way, I said no this way, I said no this way. But now you can see why the court's making a record, because if the court just said it was procedurally deficient, we'd still be here. Shauna asked, is she representing herself? Yes. The TikToker is writing this. She is representing herself in this federal case, which makes it difficult. TikToker's involvement with the case of the murder of the 4 university students and plaintiff began on November 23rd, 2022, when she began using esoteric means, intuition, claircognizant abilities, tarot cards, and oracle cards to investigate the cause of the quadruple homicide at the request of a TikTok user. I will say, even a conversation between 2 people can be defamation. We haven't talked about the Kesha case in a minute, but part of the defamation there was one text message to one person. Telling one other person can be the cause for a defamation case. However, if you tell one other person and there isn't anything else going on, it might never come to light in this way. This case gained so much traction on social media as the desire for information, conspiracy theories, or anything prior to the arrest of Bryan Kohberger was at a fucking fever pitch. It gained so much attraction and attention and traction that the police department had to say this isn't true. And there's no evidence of this. But the fact that a TikTok user said, could you make a video on this, doesn't protect you. Somebody asked me to do it, so I have to. It comes up in every single motion. I didn't just do this. A TikTok user asked me to do it. Okay, give them a private reading. No. This is not how that goes. And I think just about everyone I know that uses cards in any way is like, this is not what this is. What are you doing? So TikToker began using esoteric means because a TikTok user requested it, you guys. It makes it okay. Somebody else asked me to do it. It's okay. And Jesse said, that's why a lot of practitioners I know use an entertainment purposes only disclaimer, which won't cover you in all cases because accusing people of crimes is, even if it's for entertainment purposes, still won't cover that. What she was doing is not covered. But saying, oh, I see this or I see that, is different. That's not what happened here. Oh. This is well beyond that. Exactly. Someone asked me, so it's fine. Vibes, Your Honor. Using these means, TikToker discerned the location of the bodies, the location, the house that was well documented to have multiple rooms, the house that was in the news the second this story hit the news. You determined it was at that house. Conversations and activities of the roommates, the general location of the dog, the events that occurred before the victim's death, which there is no evidence supporting, the motive, the involvement of two potential hitmen, and a teacher who ordered the murders. Ma'am. Throughout the entire litigation, plaintiff took advantage of this by mocking TikToker for her spiritual beliefs and practices. I don't read the documents that way. And falsely stated that Gouliard made statements knowing they are false for money and clout, capitalizing off the tragedy and community's pain. Is that mocking? This was repeated in every docket that plaintiff filed in this complaint. Chief Magistrate Patricio, the judge here, joined in on mocking TikToker by reference to the esoteric practices, abilities, and derived information as implausible, conclusory, unverifiable, and arguably so outrageous as to be clearly baseless and thus implausible. That's not what he said. Also, he was quoting case law, talking about what can be relied on. And I think this part was also going to the damages. The judge did not say this about her. Ma'am, you're projecting, because that was not said in that context, even if it's true. Now, TikToker provided evidence that the disclosed evidence in the criminal trial proves there's no criminal trial, proves she made accurate assessments regarding the homicides, that the judge minimized her accurate insight as random coincidences and happenstance. Despite the judge's attempt to minimize TikToker, she is taking this very personally. Despite the judge's attempt to minimize TikToker, and the fact remains that the state disclosed evidence supports her hypothesis. You can't accuse someone of murder based on a hypothesis. But I appreciate the fact that at this point, the TikToker is now walking back her statements and saying not that they're insights, but they're a hypothesis. Okay, so it's what you think. That's not evidence. On November 30th, 2022 and December 9th, 2022, TikToker accurately discerned that the surviving roommates heard everything hid together because they felt it was better than being alone, were afraid, did not attempt to change the circumstances, heard homicide victim Xana crying, offered the victim help, but ultimately decided to wait together until, quote, they came to rescue them, led them out of difficulty and keep them safe. That's not even a sentence, but fine. TikToker discerned this even though on November 30th, Moscow Police Department issued a press release updating the public on the known facts surrounding the homicides. It stated that detectives believed that the two surviving roommates were asleep during the homicides and did not wake up until later that morning. Believed. They might well, I think at this point they knew, and I have thoughts on that. The evidence continued to be non-disclosed from the public until February 4th, 2025, when the state of Idaho filed a motion to admit text messages of DM and the testimony from DM and BF regarding their conversations with each other on November 13th, 2022. The motion this is the exact same motion, just regurgitated. The motion reveals some of the contents of a non-disclosed record. I don't even know what that means. It revealed things that were previously not included in court documents. It provides enough information to verify that TikToker was correct that the surviving roommates were not sleeping. Knew something dangerous was happening, were afraid, decided to hide together, specifically stated it's better than being alone, adapted to the circumstance instead of changing it by hiding and waiting a while to call 911. The 911 call transcript, non-disclosed by a motion filed on February 24th, 2025, provides support that TikToker was correct that the surviving roommates hid until they were rescued and led out of difficulty by, quote unquote, them, their friends. DM interviews with law enforcement are non-disclosed, but her interview is mentioned in the probable cause affidavit, well, also in the court filings. It also provides support that TikToker was correct about victim Xana was crying the evening of the murders, that she was offered help and that she ultimately did not receive that help. See footnote 9. On November 29th, 2022 and December 1st, 2022 and December 9th, 2022, she's now citing back to her own statements that have been found to be defamatory. TikToker is saying that TikToker accurately discerned the location of the victim's bodies and the approximate location of the dog. This is corroborated by the probable cause affidavit and is citing back to not TikTok because they're not on TikTok anymore. I'm not clicking through to any of these. There will be no views had. To get to the point's been made. The court denied this like 4 times. 2, but it feels like more because federal court. To get to the point, although the state of Idaho has not disclosed all the evidence that has been made available supports TikToker's defense of truth. There's no defense left. This has been found to be defamatory. It provides proof that TikToker's skills are plausible and that she can use her skills to help the public and law enforcement solve the quadruple homicide. She has been found liable in this case and is still saying, no, you're all wrong. Using plausible means to get accurate information and warn the public disputes the allegation that TikToker made false statements knowing they are false. No, it does not.
Nope.
That's my opinion!
Additionally, attempting to solve a quadruple homicide with a killer on the loose is not an, quote, act with an extremely harmful state of mind described variously as with malice, oppression, fraud, and outrageousness.
Survey says.
Going to TikTok is not helping solve the crime. if I am remembering accurately, during the ongoing and public search for Gabby Petito, there were other YouTubers who went back to their footage to see if they could find her van. And when they found it, went to law enforcement and said, this is what we found. And only after Petito was found did they then take that to social media and say, this is what we found. They went to law enforcement first and said, we think that this might help. They did not go to social media first and say, maybe law enforcement will see this, because they acted with integrity and care for the people involved in that case, in my opinion. There are ways to try to help. This is not that. And trying to categorize it as that is incredibly frustrating because it's not the same. There are ways the public can help. We've seen cases where the public has helped. We've seen cases where law enforcement ask for the public's help, but they're not asking for the public's help to go make TikTok videos about it. They are asking for the public's help to tell them. But I digress. The TikToker goes on to say that the judge's decision that TikTokers' accurate insights regarding the homicides does not change the conclusion of the summary judgment because, quote, there continues to be no corroborating support for defendant's statements about plaintiff is inaccurate and lacks critical thinking. TikToker objects to that statement for several reasons. Excuse me, federal judge, Your Honor, you're lacking critical thinking skills. Do better. This isn't fucking Twitter. You can't Twitter argument your way out of a federal defamation case. And insulting the judge is not going to make it better. And this judge has been so fucking patient. Excuse me, Your Honor. This is inaccurate and lacks critical thinking. TikToker objects to the statement for several reasons. TikToker is taking this incredibly personally. I object to your statement. One, let's hear it. Let's hear it. Let's hear it. One, this is a civil defamation case, not a criminal homicide case. No shit. TikToker does not have to prove that Schofield ordered the murder of the 4 students. You have to prove that you have evidence supporting the shit that you said, though. I love the audacity of telling the federal judge, excuse me, Your Honor, that's not what I have to prove. The judge is not the one mistaken. The judge is not the one mistaken. Instead, during the summary judgment argument, TikToker needs only prove that plaintiff has not provided by a preponderance of the evidence that TikToker made an intentional false statement. In fact, plaintiff has not provided any evidence that TikToker made an intentionally false statement. To the contrary, TikToker provided evidence that she has the skill to accurately discern untimely deaths, events, conversations, locations, and activities of the victims using esoteric means. Those words do not mean what you think that they mean. And that is not the standard. TikToker also provided evidence that she submitted her tips to the FBI tip line to help them solve the murders. And that doesn't absolve you of defamation. TikToker also provided evidence that she was correct even when the information law enforcement released was wrong. TikToker also provided evidence that quote unquote psychics are recognized by the federal government CIA, which stated that it is not required for clairvoyants to be physically present to gather and provide information, yet the information can be helpful in law enforcement cases. We have been round and round on this. You are not working with the CIA. And when the CIA works with anyone to help them solve cases, that's between them and who they hire. You're not hired. You saying that shit on TikTok is not the same. It's frustrating to me, the willful misrepresentation of all of this, the bending of facts to try to fit the most skewed version of all of this is incredibly frustrating. This is a willful missing of the point, which seems to me to lack some logic, critical thinking. This is all straw man. Therefore, to continue the circle of reasoning, TikToker's belief in herself is not a reckless disregard for the truth. Instead, it is a search for truth and justice pursuant to the Idaho jury instructions. Oh, no. Instead, it is a search for truth and justice, period. Pursuant to the jury instructions, libel or slander per se, the plaintiff must prove by clear and convincing evidence that the defendant knew the information was false or acted with reckless disregard for the truth. The plaintiff has not proved any evidence that TikToker made an intentionally false statement. Second, the withheld and non-disclosed evidence in the criminal case creates an issue of material facts in the civil case. The state of Idaho has all the evidence regarding the murder of the 4 students. TikToker does not have access to those documents and records. Okay, then don't accuse someone of murder if you don't have evidence that they did that. That solves that problem. Moving on. No, back to what she said. Since all the disclosed evidence, grand jury testimony, 911 call, probable cause affidavit, and the text message extraction supports her videos. No, it doesn't. It is more likely than not that the remaining evidence has the potential to corroborate her statements regarding the homicides. Potential corroboration is not a defense to defamation. You can't could your way out of this. You're just wasting time and trying to slow down the inevitable, which is going to be that there is going to be a substantial judgment made against TikToker, a substantial monetary judgment. She can't even say it will prove it, right? The hedging potentially proves. Okay. Plaintiff failed to provide a preponderance of evidence to prove each element of the defamation claim in Idaho. We've been through that. That is incorrect. The court went through it in their order. She is going round and round again on the order. She is wrong. She said Bryan Kohberger was arrested for murder of 4 students. He did not teach the students either. The plaintiff has no evidence proving TikToker defamed her. With no admissible evidence that defendant made an intentionally false statement, there's no way the judge applied the relevant defamation laws to the evidence that does not exist. If the evidence does not exist that there was evidentiary support for your statements, then there's no defense. The judge found TikToker liable for defamation based on his beliefs that claircognizance or psychic abilities are implausible. He was wrong and made an error of law. Nope and nope. What he said was there is no evidence and that your thoughts are not evidence. Plaintiff made an intentional false statement about damages. TikToker goes on to say, plaintiff alleges that defendant's TikTok's videos harmed her reputation and caused physical injury. That's not how she said it. Plaintiff claims to have suffered damage to her reputation, career, and mental health. I don't doubt that's true. I don't doubt that's true at all. Do you? Plaintiff has not suffered any harm to her reputation nor career. How do you know? That's what the trial on damages is for. Also, this is defamation per se. She doesn't have to prove it. Here's the thing. For liability for defamation per se, you don't have to prove damages. So she didn't have to prove damages. Though I don't doubt that this took a toll on her career, reputation, and mental health. She said plaintiff has not suffered any harm to her reputation nor career. She's supported by the University of Idaho Teachers Union, has not lost her job. Can you imagine if she lost her job over something somebody said about her on TikTok? I know it happens to people. It just breeds a lawsuit. And then the university paying a ton of money. She's not lost her job, has not lost any wages, has not provided evidence of any mental health issues. She has been deemed a hero online. See plaintiff's GoFundMe. Pursuant to plaintiff's GoFundMe page, the University of Idaho chapter of the American Federation of Teachers, the Idaho Federation of Teachers, and the National Legal Aid Committee with the American Federation of Teachers have all moved forward with contributions to her legal fees, providing a significant amount of financial support. Good. That doesn't mean you didn't defame her. Despite the plaintiff's lack of evidence, despite the fact that plaintiff lacks damages, you misunderstand the law. Despite the fact that plaintiff provided no evidence that TikToker made an intentional false statement, if you can't back it up, it's an intentional false statement. And despite the fact that plaintiff failed to meet all elements of a defamation claim, the magistrate allowed the plaintiff permission to amend the complaint to add the requisite punitive damages, or to add the request for punitive damages. That is legally improper according to Idaho Supreme Court. Footnote 11. And plaintiff's attorney. Footnote 11. Some blog article. The context matters. In Davis versus Blast Properties, Inc., that's an improper citation. Idaho Supreme Court held that trial courts are required to conduct a careful examination of the evidence to determine whether there's a reasonable probability that the evidence submitted is admissible at trial, sufficient to support an award of punitive damages. According to Schofield's attorney, reiterating Idaho Supreme Court, to assess whether the evidence submitted at trial is sufficient to support an award of punitive damages. This is not even about this stage of the proceedings. This is why lawyers, this is not even about this stage of the proceedings. This is procedurally improper. No, yeet. This entire argument is just yeet. None of this is relevant. I'm not even reading it. It will just make all of you understand the law less. We're not here to make the law nerds dumber. Oh my God. That's not correct. We're not assessing a jury award of damages. We're assessing the court's ability to allow the amendment of the complaint after a finding of liability, for fuck's sake. You couldn't even put this case on a law school exam without students complaining to the school that it's too circular to even deal with. The students would be like, if what? The judge agreed with plaintiff that TikToker, I'm trying to read this sentence. Judge agreed with the plaintiff that TikToker, but did nothing to formally obtain the evidence providing professor's connection to the murders during the discovery or otherwise make any effort to incorporate into her summary judgment briefing. This statement is blatantly false and fascist? Factious? No, I don't think that's the correct. No, I don't think we're even in the, I don't even think we're in the right realm. I'm correct. Treating serious issues with deliberately inappropriate humor or flippant. Facious? No, not accurate use. This statement is blatant. I mean, Emily, no. She actually might be using it properly, and I am just disagreeing with her perception. But the meaning of the word is treating serious issues with deliberately inappropriate humor or being flippant. I don't agree. Oh, wait, somebody has a word of the day on this. Hold on.
My coworker,
Side quest. Emily, you're now disassociating from this case. Yes. We're going on a side quest. Come with me, chat. I have no idea whose YouTube channel this is. Oh, is this dictionary.com's YouTube channel? Great. Side quest, word of the day. At least something will be learned. We will not all be made dumber for reading this. Look, there's a point. Hold on. The point, why is there a
my coworker
slider?
Mike is a
Mike. Let's see what dictionary.com has to say.
funny guy. During a tense meeting the other day, he really lightened the mood with his facetious remarks.
Facetious.
Facetious is
I can't, when you see the neurodivergence in real time, there's no way I was connecting the word that I know to that spelling. Emily, you have no phonemic awareness. Correct. I have no at all phonemic awareness. I'm not here to make us all worse. I don't think I ever knew how that word was spelled. Ever. Emily, where does your vocabulary come from? Listening to things, not reading them. Ooh, the neurodivergence in real time.
my coworker Mike is a funny guy. During a tense meeting the other day, he
Fantastic.
really lightened the mood with his facetious remarks. Facetious is the dictionary.com word of the day. It means not meant to be taken seriously or literally. Facetious comes from the Latin word, meaning a jest or joke. I'll say this about Mike. While he's sometimes facetious, he definitely knows how to read a room and be serious when needed.
Well, good for you, Mike. Zero phonemic awareness. So I never would have. I never would have. The way I grip, and this is a issue sometimes when you can't even get close to the spelling, when you're just like, even Grammarly can't help me now. I do my best, but I also voice to text a lot of things so that I don't have to worry about it. How is that pronounced? Facetious. Look, words in English are often spelled dumb. I am so sorry to everyone who tries to learn English. I don't know what to tell you. I don't get it. Lyndon, was that a real office or a green screen? It screams green screen to me. It also screams corporate word of the day, but I'm here for it. I needed to hear it out loud. We had a great little shift from there. She speaks, said former English high school teacher. There are tons of people who have no idea how to pronounce words they've only read. It's common. Give yourself grace. Thank you. You solve complex legal issues. I do, but I cannot sound words out at all. All right. Let's get back to this objection. I still don't think the statement was facetious. Now that I know that's how that's spelled so weird. It looks completely wrong to me. But anyway, I don't see how the statement is facetious, nor is it false. To suggest, oh, she's indignant. She's indignant. Ugh. Angel said English is my second language, and sometimes I think I'm dumb or the words are dumb. The words are dumb. Angel, it's not you. English it's a hodgepodge of a lot of different origins, and the spellings are all kinds of honked up, and it doesn't follow a pattern like a lot of other languages do. A lot of other languages, you can just follow the pattern. In English, you can't follow the pattern. And then regional, I don't want to say dialects because that's not quite right, but regional pronunciation of words also varies. So that might not be the way it's supposed the way it's spelled might not be the way it's pronounced based on the region. Because they're like, no, this and this and this. And it's just, you can't even learn that unless you're just there where somebody tells you. So it's not you. All right. I'm sorry. We got to the indignant. To suggest that TikToker interfere with the state's criminal case by issuing subpoenas to potential witnesses in the criminal case, subpoenaing the phone and financial records of the witness and victims, and use the civil discovery process to gather evidence that the state gathered in its criminal case is facetious. Oh no, that's not. That's dead ass the wrong use of that word. You're in a civil case. Also, you have no basis to get a lot of those subpoenas. So, additionally, TikToker informed the judge in the summary judgment hearing, as well as her summary judgment briefing, that the evidence was in the possession of the state and non-disclosed. No! Saying it more times, different ways does not make it true. You have to have evidence when you make the statement. What the state has since gathered is irrelevant to this case. Not to mention, she goes on, TikToker's attempt to gather evidence by subpoena from social media platform Meta was rejected by Meta and quashed by the judge. Yeah, it was improper. Meta cooperates with law enforcement in criminal cases, not litigants of civil cases. That's not true. Meta can disclose things in civil cases if they are a proper request. Further, the judge, armed with the assumption and false belief that claircognizance is implausible, inaccurate, warned TikToker that her discovery attempts would be denied. Wow. She's gone a very long way to misinterpret what the judge said to then gaslight the court. But you told me I couldn't. That's not what the court said. The court said abusive discovery attempts would be denied. The court never said, or overbroad discovery attempts. The court never said you couldn't do discovery. But these were improper discovery attempts. You still have to follow the rules of discovery. Ask your lawyer. Your lawyer should well know the civil rules of discovery for Idaho. Ask your lawyer. The gaslighting. This causes due process issues, negatively impacting TikToker. If TikToker is required to prove a crime, that's not the case. And prove the crime that professor ordered the murders of 4 students to hide her affair with one of the victims, then TikToker should be granted the authority to gather criminal evidence and authority to access non-disclosed public records in the criminal case. See, this is such a straw man argument and a red herring. This is multiple logical fallacies in one. Nobody said that that's what you're required to prove. TikToker has not been granted either authority. Good. Additionally, it is not appropriate to subpoena the witnesses in a state's criminal case. Why? If you talked to them before you made the statements, then it would be proper to subpoena them. If you've never had any conversation with them, then it's not proper to subpoena them because they have no firsthand knowledge of this case and can provide no competent evidence. Perhaps it is best to focus on the elements of the civil defamation claim, considering this is a civil case and TikToker is not a criminal prosecutor. Well, thank God for small favors. The judge is focused on the wrong evidence. Your Honor, you're focusing on the wrong thing. Use your critical thinking. No, ma'am. No, ma'am. TikToker has adamantly reminded the court, Your Honor, if you just listen to me, the level of self-snitching in all of this. TikToker has adamantly reminded the court that the evidence required in this case is for the plaintiff to prove by a preponderance of the evidence. Ma'am, you misinterpret repeatedly. The burden shifted in the motions when the court found that plaintiff met their burden. And you could not dispute that. The court found that. The plaintiff is required to prove by a preponderance of the evidence that TikToker made intentionally false statements that is defamatory and caused harm and damages. Not required to cause harm and damages. This is per se. Plaintiff does not have any evidence that meets the required elements of a defamation claim in Idaho. The court disagrees. I agree with the court. Conclusion. For the reasons above, Your Honor, give me what I want. The court should enter its order consistent with defendant's above objections and dismiss the complaint sua sponte for a want of jurisdiction and in the best interest of justice. TikToker, pro se. June 12th. Emailed everybody. So, Emily, do they have a trial date for damages? Not yet. But let's take a look at the required joint status report submitted by plaintiff's attorney from June 13th. Joint status report. Pursuant to the court's order, May 30th, the parties jointly submit the following order. Trial date. The parties propose the court schedule a 4-day trial on damages only in February 2026 or March 2026. Is this going to go to trial the same time as the Corey Richards case? It might. Judicial settlement conference. The parties do not have a mutual interest in participating in a judicial settlement conference. I think that is a huge fucking error. A huge error. Plaintiff is agreeable to participating in a judicial settlement conference. Defendant is not agreeable to participating in a settlement conference. Dated June 13th. I think that's a massive error. Dr. Who said 4 days over this? Yes, 4 days. Because the jury is being asked to award damages and punitive damages, so they need to see how bad it is. So 4 days includes picking a jury, so probably 2 days in front of the jury, 2 days to pick a jury. And they're going to need to show hundreds of TikToks and YouTube videos. They're going to need to show everything that the defendant said. They're going to need to show the cease and desists, the videos that react to the cease and desist, because they're asking for punitive damages, so they need to show the jury everything that happened, and then some of the media articles, etc. So yeah. Peggy said, why do they have to wait so long? Probably because of counsel's schedule. Trying to schedule with lawyers is incredibly difficult. That's probably because of the schedule of counsel. So that's not, in lawyer brain, that's not too far out. All right, here's the judge's latest order as we've led up to all of that. This is from June 17th. We don't have any docketed items since then. So we will continue. Order regarding defendant's objections to magistrate's decision and order on May 30th. There we go. Pending before the court is defendant's objections. For the reasons that follow, defendant's objections are misplaced. Oh boy. This will be a jury trial for the damages. Plaintiff Rebecca Schofield initiated this action against defendant on December 21st, 2022. The parties filed consent to magistrate judge on April 16th. Over 1 year later, defendant filed a request for reassignment to a U.S. district judge, construing defendant's request as a motion to withdraw consent. Construing the request. Construing the request as a motion to withdraw consent. The undersigned referred the request to the U.S. district judge. Only a district judge may rule on a motion to withdraw consent to the jurisdiction of a magistrate judge. The district judge should consider whether the requesting party has shown either good cause or extraordinary circumstances. On November 13th, the court's laying out the entire procedure against this judge. On November 13th, the district judge denied defendant's request, reasoning in part, in summary, TikToker has failed to establish any extraordinary circumstances justifying reassignment of the case to a district court. The record does not show that the magistrate judge was biased in any manner towards TikToker. Instead, the timing of the motion to withdraw her consent and her Rule 59E motion filed shortly after the judge's granting of the partial summary judgment and leave to assert punitive damages claim indicates TikToker's real motivation. It's to avoid the magistrate judge's rulings. TikToker's only recourse to challenge those rulings, however, is an appeal following a final judgment. Excuse me, I don't like this judge's orders. Can I get a new one? I'd like to talk to your manager. Excuse me, Your Honor, I need to talk to your manager. Can I get the boss judge? Boss judge, this judge seriously needs to do better and is lacking critical thinking. I need a new one. Yeah, that's not how that goes. Relevant here, the import of the judge's decision was that the party's previous consent to the magistrate jurisdiction remained and continues to remain intact. On March 15th, 2025, defendant filed a motion for reconsideration relating to the court's above referenced June 6 Memorandum of Decision order granting partial summary judgment in plaintiff's favor and allowing plaintiff to assert a punitive damages claim. That was arguing newly discovered evidence. We just went through that motion. Footnote 1. Defendant previously moved for reconsideration, alteration, or amendment of the court's June 6th order. The court denied that motion February 4th. So the court denies a motion. She's like, and another one. What if I argue it this way? Maybe if I say it different, you'll agree with me. No. The undersigned denied that motion on May 30th. Even assuming that defendant's reconsideration efforts are procedurally proper and the referenced evidence is both newly discovered and admissible, defendant's motion fails. Defendant's motion suffers from a fatal flaw. The evidence does not change the disposition of the case. Now, via the at-issue objections, defendant requests that a U.S. district judge consider her latest objections and reverse the decision of the magistrate judge. Deny the plaintiff's motion for summary judgment and deny the plaintiff's request for leave to amend. In support of this request, defendant relies upon Federal Rule of Civil Procedure 72A. Critically, however, this authority applies to matters referred to the judge by a district judge. Because the undersigned's jurisdiction was consented to up front by the parties, she should have asked her lawyer about the impact of that, pursuant to the Federal Rules of Civil Procedure, and this is not an action referred to the undersigned by a district judge, defendant's referenced authority is inapplicable, and defendant may not engage in what amounts to an appeal of the undersigned's order to a U.S. district judge. Rather, following the consent of the parties in this case, an aggrieved party may appeal directly to the appropriate United States Court of Appeals from the judgment of the magistrate judge in the same manner as an appeal from any other judgment of the district court. Go appeal it. In denying defendant's request, the judge stated, if TikToker disagrees with the rulings, the proper method to challenge them is by appealing. In this case, TikToker must file that appeal with the Ninth Circuit once the judgment is final. You think that's going to happen? I do. An appeal from a judgment entered by a United States magistrate judge will be directed directly to the United States Court of Appeals for the Ninth Circuit in the same manner as an appeal from any other judgment of this district court. Defendant's objections are thereby procedurally improper. There is no opportunity to quote unquote object to the order short of an appeal to the Ninth Circuit. Go tell it to the Ninth Circuit. In this respect, defendant is directed to Rule 54 of the Federal Rules of Civil Procedure and Title II of the Federal Rules of Appellate Procedure. Additionally, owing to the interlocutory nature of the undersigned's June 6, 2024, February 4th, 2025, and May 30th, 2025, defendant is advised to consult 28 U.S.C. 1292, addressing appeal of interlocutory orders, discussing how an order establishing liability but not damage is not a final order. The court's like, also, you can't appeal now. This is not a final order. FYI. Just, you can't do that now. Order. Based on the foregoing, it's ordered that the objections are rejected. Get the fuck out. That I added that. The court didn't add that. I added that. Oh, the patience. The patience of this court. So now I'm waiting to see if the court is going to set a trial date for this in February or March of 2026. What happens from there? Will TikToker even show up? Because the address the TikToker uses, and I don't show it because I don't know if it's a personal residence or not, because TikToker is pro se, and I'm not sure that TikToker is not just putting their personal phone number, address, and email on all of this. So I'm not going to put it on the internet the best I can avoid. The addresses TikToker uses are in Texas. TikToker has indicated numerous times that TikToker is in Texas. Can I see or foresee a circumstance where TikToker no-shows trial? I can. But then the court would have to order TikToker to trial. Then if TikToker still fails, then you can see bench warrants and contempt and things like that. But at this point, I imagine when the court sets the trial date, the court will have to directly order a defendant to appear. I think there is real concern that TikToker will just no-show. And then I would have to look at the case law about whether a trial regarding a civil defendant can take place in absentia. And maybe then, if that's the case, the plaintiff might choose to waive jury and just go forward with the judge deciding. We'll have to see. We'll have to see what happens. I ran out of water. So we'll have to wait and see, but I could see that as a scenario. And the judge will have to make sure that that is probably verbally issued and among the rest of it. But yeah, I can see that happening. So where are we with that defamation case? It's been going on since December of 2022. The plaintiff has won on liability, is waiting on damages, and the just defiant level of pro per filings is not slowing down anytime soon. And I have tremendous empathy for the plaintiff in this case, because I don't know what you do. Like, what do you do? And how do you ever seek recompense from someone that's going to do everything they can to avoid responsibility and is really shamelessly just saying, you're all wrong? It is a difficult case. Also, why is this case in Idaho? The plaintiff filed it in Idaho. The defendant did not properly complain of jurisdiction or lack of jurisdiction. So there was no court decision that Idaho is the proper place to sue for this, which is why it's different than some of the other cases we've seen that I've covered of defamation online. We didn't go through all of those international shoe analysis, et cetera, because the defense never raised the issues of jurisdiction properly, and the defense conceded to jurisdiction. Can the professor get lawyer fees? The professor can get lawyer fees in addition to all the rest of it. The question isn't really, will they be ordered? The question in this case is, will they be able to get them and go get them? And that's a difficult thing. But I really can see that the professor might just be like, no, I refuse to consent to your authority. Come get me then. It's so frustrating. But everything that's going to go before the court, in this case, is going to be seeking a monetary judgment, seeking monetary relief, and seeking punitive damages. I think it is unwise for the TikToker not to deal with judicial mediation, but it seems that the TikToker feels that the court and everyone else are out to get her. And she doesn't have a lawyer to explain to her how this works. So she's going to go based on her perception and not based on what is. So good luck with that. It's going to be a difficult one for the professor. I feel for the professor. I'm frustrated for the professor. And I think we see this tension building on social media where people think they can just say whatever. And it's one of the ways that we're going to see, I think, more of these fights. The difficulty is litigation is expensive. And there are many that have been defamed online that are like, I can't either afford to go through that process monetarily or emotionally, physically. Or this is a slap fight that's never going to go anywhere because at the end of the day, the person who's saying all this shit about me doesn't have any way to recompensate me and refuses to stop. So we are going to continue to see more and more defamation suits arise out of online. I think defamation suits against an individual creator can go further than defamation suits against media outlets, though a lot of media outlets have legal teams in-house that they run things by that gives them additional layers of protection. They also have layers of lawyers. And a lot of them have different types of journalistic privileges that don't apply in the TikToker case. This is not a journalism case. And the TikToker has never asserted any type of journalistic privilege ever, and can't now. It's way too late, which is why I didn't talk about it earlier. Can't now, way too late. TikToker privilege doesn't exist. Somebody asked me to cover this on TikTok is not a defense. And you can't say whatever. There are boundaries and responsibilities. And the Lolly in the chat said, hold TikTok accountable. You can't. You can't hold TikTok or other platforms accountable for the things people say on the platforms based on the laws of the United States. And we've gone through Section 230 and the rest of it quite a bit, but there are protections for the platforms that host content. So you can't go sue the platform. And there's a balance to that too, because if you start holding the platform responsible, will platforms just start taking things off that they don't agree with? Will platforms start applying their rules evenly or unevenly? Or will platforms be like, fine, if you can sue us for some shit that somebody says on our platform, we're taking the whole platform down and we're not gonna give anyone a voice. Go host it yourself. Go host it yourself. So platforms can't be sued. Well, they get sued, but they can't be held liable for things that individuals say on their platform. They are not considered publishers, though there are pushbacks to Section 230 that keep going around and around and around. So if they can be held liable, if they become publishers, they can be held liable. And if they become publishers and can be held liable, social media as we know it will completely change. Because while I could see a day where they're like, no, individuals can't broadcast unless they are vetted and agree to, I don't know, hold up the same, I don't know. I don't want to see that happen, but I can see the continued push-pulls because there is difficult remedies here. And the First Amendment is not without limitations in the realm of defamation and other things. But if we start seeing platforms operating as publishers, do we see the, FCC taking a more saying that all online speech falls under FCC regulations. Like, does streaming then fall under those guidelines? Like, then where are we at? So it's a tough tension, and it is not easily solved. Riley asked, can the judge put the TikToker in jail if she doesn't stop? No, it's a civil case. If TikToker violates court orders, that is an outside holding contempt possibility, but this is a civil case. Monetary damages are monetary damages. So that. We went through the TikTok hearing at the Supreme Court. It wasn't about this. It was about the algorithm, but I've covered some of the Google lawsuits. I can't hear FCC. I know the FCC won't let me be or let me be me on MTV. Yep. There are rules, and those rules, the constitutional rights of any given individual and the rules that govern platforms oftentimes end up bumping up against each other and at odds. And these are cases where I can see the desire to be like, how do you help in the situation of this professor? Like, how do you help that? And where are the boundaries of that? And case law applies very broadly. There's not going to be case law that applies to just this case. So this case is following the processes and procedures that every other defamation case that we covers. Lyndon said, there's no criminal defamation. Agreed. Criminal threats, but no criminal defamation. Mavka said, what if Bryan admits that the professor is involved? What occurs with this case? There's no way to prove that the professor or the TikToker knew that. And there's also no evidence to prove that that's true. Bryan Kohberger can say whatever, but saying whatever is just hearsay. So it wouldn't change things in this case because the TikToker has to have evidence to prove that they knew the things that they said were true at the time that they said them, with evidence, not vibes, not I just want to name call, not are there others involved here? The TikToker didn't go on TikTok and say, I wonder if there's others involved here. I wonder if this is more than a random crime. She named an individual, said that that individual was soliciting this murder, said why, said that she was involved with one of the victims, and on and on and on. This wasn't vague. So, Jennifer, there are videos of me covering it on the channel. Let's get to some questions quickly because then I've got to scoot. We haven't done this today, so instead of I have questions.
The FBI!
Hey, FBI. The TikToker would like to work with you. Let her know if you're interested. Did the crime scene speak to her like Trooper Paul? It seems so. And she has doubled down on all of that. Kristen said English is 3 raccoons hiding under a trench coat. Yes. Taylor said, I had a tooth extracted Tuesday. I was super freaked out. And after the x-ray, I put in an earbud and listened to you. Thanks for the distraction. I'm here for it. I carry my earbuds everywhere. Laura asked what a lot of you have asked in the chat about the TikTok psychic. Can the families of the victims also sue her? I'm going to address this on practicality and not legal theory. So hopefully that is not unsatisfactory. But practicality, why? Like, there is nothing, I don't think, for them to gain by then entering into the fray of going round and round and round with somebody who's going to represent themselves pro per. It's just putting money in a pile and lighting it on fire. Because paying for lawyers to do this with a defendant who I would suspect is not going to have the level of resources that they are trying to protect, that they even care about. There's nothing to gain at the end of the day. And I don't think they need a court to tell them that this is fuckery. I hope that they can just ignore that there are people saying these things and say that this is just fuckery. So it's not going to help move them forward. Also, with everything that the victims' families are dealing with in their grief, in dealing with Bryan Kohberger, in dealing with that case, I can't see anyone wanting to bring this into their life. It is not going to be easy, and it's not going to let them start to close a chapter and start to grieve outside of public view. It would keep this going for another 4, 5 plus years. And I can't see anyone wanting to do that. Gringa said, in such a judgment, could income be garnished? If there's income, yes, it can. It's not easy. It's not easy at all. So let's continue on. Hey, EDB, can you put the polls on YouTube? Can you please put the polls on YouTube or in the Lawnerd app so those of us who need to watch replay crew can participate in the pools? Carrie, when I do the polls, it's normally in real time for deciding what we're doing on the stream. So do we need more background on this case is generally a in the moment decision. When we have polls about what content are we doing in what order prospectively, I do put those on the app and in the member spaces on YouTube at times. But when we're in the moment on stream, those are things I need the info for as we're on stream. So that's where I'm at with that, but I appreciate it. I will keep it in mind. Becca said, just received my purple Lawnerd hoodie and tank to add to my collection. So soft and perfect. Thanks for the new launch. You're welcome. It's more of a refresh because it's a lot of the designs we've used before, but we were trying to refresh, restock, and bring things in different ways. And we're taking a look at what needs to be restocked from the restock. I have worked on death penalty cases. I have not prosecuted death penalty cases. Lauren, congratulations on over 3 years. And a lot of the death penalty cases, I can't say a lot. That's unfair. Some of the lawyers that I worked with that were handling death penalty cases, a substantial number of them involved child victims as well. So I will never talk about those online. So, Bridget said, I work in trade shows and conferences. The politics and the rules and the regulations is wild. Yeah, it is. There's a lot of the inner dealings of who owes what to what and how much of a percentage of people are taking the contracts on those are wild. Belle, happy birthday. I hope it is a very good one. It's the Professor and Marianne. I wish it was. I feel so badly because there are just places where the law can't fix it. And the law just can't fix it. You can't undo. And we talk about that a lot. It's going to be really hard when we get to the Kohberger sentencing. It's going to be a heavy and highly emotional day. The Kohberger sentencing is going to be hard because at the end of the day, the law can't really fix it. Whether they seek the death penalty or didn't seek the death penalty, it's not going to change what happened. And the law does not have really a mechanism to stop things from happening other than hoping to be a deterrent where people are just like, yeah, no, I rules, there are rules, morals, rules, rules, we're following the rules. You don't do that. There's rules. You hope that it acts as a deterrent, but it doesn't act as a deterrent to everyone. And when we're looking at some of the civil stuff, people are just like, I thought it was fine. It's not fine. And trying to seek a money judgment, we saw this a bit in the Cardi B case. You seek a money judgment, and then you spend years trying to chase that money judgment down. Somebody doesn't just pay it back. You're signing up, when you're going into civil litigation, you are signing up for a years-long process plus. And a lot of prospective plaintiffs, when they sit down with lawyers and talk about, okay, it's going to start at $10, $20, $30, $50, $100, $200, $500,000 of a retainer up front. That's where we start. And then let me tell you what this process looks like. We'll probably talk about it a little in the podcast when we talk about what depositions look like, et cetera. And then let me tell you what the discovery process can look like. And if you are looking at suing someone who is unlikely to mitigate their behavior or pay, you could actually do more damage to yourself by suing them. When we cover the Ryan Kavanaugh case, I don't think Ryan Kavanaugh, in trying to sue Ethan Klein, understood how the internet might respond to that. And I don't think that it was something the lawyers anticipated with, like, this is the hornet's nest you're going to open in this lawsuit that I frankly think was stupid. We need to circle back to the ruling on that. But trying to resolve civil issues in court, especially depending on where you live, courts are incredibly backed up, especially after COVID. So locking yourself in something for 4, 5, 6 years that is not good to you or not good for you is really hard. There's been times Dr. B and I in business particularly have looked at, are we going to pursue this or not? And sometimes you look at it and go, it's not worth it. The wrong that's been done to us is not going to be resolved in court. And at the end of the day, do I need a judge to tell me I'm right? We know we're right, but we're not going to do that. Debbie said, is the podcast for members only? No, it's not, Debbie. It's on the Emily Show channel. The mods will put the link down below. The Emily Show is also on your favorite podcasting app. It drops on most Mondays, but I do record it with the members in the background. So there is an entire tailgate that happens. What is in the podcast and what is in the recording of the podcast are not the same. But the podcast comes out on Mondays. So the members will see the members will see all of it. So Kate P, I might I'm just not I haven't pulled all of them yet. But when we talk about copyright, I will look at grabbing the new copyright suits. I might do it on the podcast when we talk about copyright and keep them all together, because not our audience, but derailing with the discussion about everything else in that case can be much. Trying to stick to just the copyright of it all can be harder to narrow down. But yes, I can look at that. It's going to take a minute for me to get to them, because it's just going to take a minute for me to get to them. We have so many cases that we're behind on. So when we look at, the internet repercussions and boundaries, it gets hard. It really does. So with all of that, I'm going to answer a few more questions and we'll go from there. Let's see. Mildred said she didn't even see the lawsuit coming, or thought that the lawsuit would be an additional clout circus. Because again, when there's a lawsuit online, and this is why I don't want to put up TikTokers' links, names. I'm not pulling up the defamatory statements. I want to cover this case. I do not want to bring more attention to the TikToker, their accounts, or their behavior. So it is a balance for me of putting oxygen on it, but I think that this should be talked about, because what do you do? Like, this is so out of the blue for this professor who's like living their life, doing their work, and they have their name up on a website, to then be in headlines across the country and be getting death threats on their phone at work is such a wild and awful thing. And if people didn't go real world with it, I don't know if it would have been different, but the media picking it all up doesn't help. Like, why are there so many headlines about this? The media picking this up from TikTok doesn't help. And the laziness of like, oh, TikTok's talking about this. Oh, everybody on Twitter said this. What the fuck? That's not an article. Go find sources or something. Everyone on TikTok's talking about this. The headlines make it worse. And then people going real world make it worse, because people came for the professor, her job. In the other filings, we saw that they were leaving her death threats on her voicemail, doxing her socials, like all of it. It just can't make it whole, because she still had to live through that. And I'm sure her colleagues were like, this is some bullshit. And part of the reason I'm so frustrated by it is because any of you in your normal life can have somebody online get a wild hair and put you into years of litigation. It's hard. And at what point does it become digital harassment? And are the digital harassment laws strong enough? But then again, where are the boundaries of harassment and free speech? Like, just because you hate it doesn't mean it's hate speech, right? Michael Scott taught everyone that. And so it's really difficult. So yeah. CS Tier said the podcast is on YouTube too. Yes, the Emily Show YouTube channel, the podcast is there, or on a podcasting app. You can find it either way. So it's just a frustrating case, which is why I'm still covering it, because A, the audacity, and B, where do we all decide to not give these things oxygen and maybe mitigate some of the harm? And how, one of the things I try to navigate in conversation together with y'all, because y'all are so smart, law nerds, how do we navigate hearing people, listening to their stories, and also waiting for the facts and waiting for both sides without devaluing what people have to say and without devaluing people coming forward to speak up? Where can we find the boundaries of patience for all the facts to come out while still being supportive? And I think that's one of the hard things on social media right now is oftentimes people can jump on social media and be like, well, if we're not speaking about this enough, why is there no immediate recrimination? Why isn't somebody fired? Why isn't this? Why isn't this? Why isn't this? But sometimes we have to wait until we get to all of the information coming out. And where is the patience for that? Because in some cases, we might never see all the information, even when awful things have happened. And where's the boundary for that too? So it's a hard balance. I don't disagree that it's a hard balance. But some things, when you have someone on TikTok making wild allegations about somebody committing a murder, where is the boundary of like, let's not press publish on this? Let's not bring more light to it. Like that. I don't know, man. It's a tough thing. So it's something we're going to continue to navigate together and talk through together, because I don't know what the solution to that is. And I feel that this case needs to be covered to its end, because now I'm invested. I want to see how this ends. And hopefully it reminds that patience is necessary. It's why I don't jump into cases the second they hit the news. It's why I don't cover breaking news. I cover law. I cover what happens in courts. And I want to see both sides of a thing. And there's times both sides change my mind. There's times that both sides bring to light facts that I never even considered. And waiting for it to play out in court, we know there's a process. With court, there's going to be an allegation and a response. There's going to be a complaint and an answer. There's going to be procedure. There are rules on how things are argued. And in any motion, there is a motion, an objection, and a reply or an opposition. And so you have process where there is room for both sides to be heard and some boundaries about telling the truth. Though I think we're seeing those boundaries get a bit stretched. I think we're seeing the boundaries in court getting a bit stretched. The information and belief is doing a lot of heavy lifting. But there's room for process, wherein other things or rumblings of new cases, we're not always at the process phase yet. And so I oftentimes will find myself choosing to wait until we get to that process phase. So hopefully that makes sense, because I know law nerds, you're with me. Even if you're like, I want to know about this case, we might get there. Right now, we're going to be catching up on cases that we are behind on, and I'm going to be catching up on getting outside and doing things that I very much enjoy before we get into the fall. So that's where we're at, law nerds. There's time for all. There is time for work. There is time for hobbies. There is time for fun. There is time for family. And with that, you guys are the best. I love getting on the internet and having a chat with you. I honestly think that together we remind people that the internet doesn't have to be an awful, toxic, horrible place, and that we can have conversation about cases and we can have opinions and still wait for the facts. I do not love some of the defendants. When I have feelings, I let you know them. I don't like what the TikTok psychic is doing. I don't like it. But when she makes a good point in arguments, which has happened, I'll tell you, because I think differentiating the two is important, because we can dislike someone and they can still be right, even when we don't like it. I don't like you, but you make a good point. And I think not us, but I think that gets harder and harder to not intermingle, because the internet can get very loud about it. It's like, no, this person sucks. Nothing they say can be right. Nothing wrong can ever happen to them. They suck, so they can never be right. They can never be wronged, and we can never have a conversation. And that's just not true. People can suck. Oftentimes we see that in these cases, but it doesn't mean wrong hasn't been done to them. It doesn't mean they're not right. It doesn't mean they don't have a legal case, even if they suck. And that's what we do, because it's hard. I appreciate you, law nerds. I will see you in the app, probably not on social. My social is just basically a banned fan page at this point. But if anything happens over Friday, I'll keep you posted. And then I will see you next week. The schedule will probably get I have to book flights. The schedule will probably get a little weird as I go to do some DCI stuff. If I end up creek ending, I'll let you know, but I think that that's not advisable with my leg giving me. I think I should probably be responsible, but it's Dave, but responsible. So with that, you guys have a good weekend. Hopefully the weather's lovely where you are and you have some time to do the things that make you happy. I will probably put up some other posts in our member spaces this weekend. I have some video to share in the app. So those of you that are members in the app, I have some stuff that I can share there from DCI, and I'm very excited to share. I just haven't had a chance to sit down and parse it so I can share it. You guys are the best. Thank you for being a shining example of the best of humanity. You guys are great. And I think we are an example of how people can be fact-based and then have fun. I will see you guys soon. Thanks for being awesome. Bye, law nerds. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a law nerd.